Item number 96. Item number 728.
May it please your lordship, I beg to mention item number 16 of the daily list. Lordship, we have sought some information from our petitioner. Lordship, may kindly give us 1 week time.
It's a fresh matter.
Yeah, yes, your lordship. Lordship, some information are yet to be.
How much time you want?
Lordship, 1 week.
It's on 1 week. It's the date of after week. Yes.
May I please, Your Lordship?
Haan, sir.
My lord, item number 4.
Oh,
Yes, my lord.
yeah.
That has been rendered infructuous, my lord.
I'm for the applicant, my lord.
Is for the applicant, my lord.
Begin for grant of leave. It has become infructuous. Now, Nikkei. And you are for the applicant?
My lord,
I am for the respondent department.
You are for the respondent department.
My lord.
Yes.
My lord.
Do you agree?
Yes, lord.
Who is for the petitioner? This applicant.
He is
I'm
for
for
the-
the, I'm for
You
the.
are for the.
Mine.
Okay, Nikkei. The parties are in agreement that this IA number so and so and the writ appeal has become infectious, dismissed as infectious.
Obliged. May it please your lordship. So far as the item number 24 is concerned, my lord.
24.
24, I need to file reply, my lord. The two respondents, they have filed their affidavit in opposition, my lord.
Fine.
3 weeks, my lord, kindly.
File rejoinder.
Rejoinder, your lord. I am for the petitioner, my lord.
Who the respondents have filed their.
My lord, the two private respondent and government, they have filed. My lord. I already informed, my lord.
You also want to file reply to the rejoinder to the reply to the government and the private.
My lord.
Both.
My
Nikkei. And concept of the submitted that he is in receipt of reply on behalf of state as well as some private respondents. He wants and he wants to file and he seeks some time to file rejoinder. Those replies. Would stop time period for is granted. How much time?
3 weeks, my lord.
List on so and so 3 weeks.
Deeply obliged.
May I lordship? Lordship, paying for listing one IA lordship for rectify lordship. Day after tomorrow, if possible, lordship.
Day after tomorrow.
Yes.
What's the urgency?
On
What's the urgency?
no urgency, lordship. That applicant is about the 74 years old, lordship.
Then would be listed in registry will get it listed if there is any application for
If possible on Monday, lordship.
No.
12th January, lordship.
I think he was. But for correction of order.
Yes, lordship.
correction of order.
For correction. Yes,
Monday.
must.
May I please, Your Lordship? I beg to mention item number 32, Your Lordship. We have taken.
32.
Yes, Lordship.
Yeah.
We have taken the consent of the respondents at Your Lordship. So, my lord,
This matter is urgent. At the joint request of the parties, matter is urgent. List on so and so.
after
Which
3 weeks.
date
Yes, Lord.
you inform the date to the court mark. Yeah.
Deeply obliged, Your Lordship.
Lordship, I beg to mention item number 36 with the consent of the other side. The matter may come up on some other date.
Two more.
Date.
My lord, I'm appearing for the respondent state. I pray that the matter may be fixed on the 12th of March, my
Which one? Which one?
12th of March,
Which matter?
item number 36. my-
Yeah. Yes, 12th March, ma'am.
Obliged.
Maybe the lordship. Lordship, I beg to mention item number 14 and 34. My senior is now out of station, my lord.
14 and 34.
वो पहला दिन ही सीनियर नहीं है तो
When you want?
My lord.
When? You want
After,
adjournment?
1 week,
Which
my lord.
date?
After a week, my lord.
Next week may be taken. After a week. date, then respond at the request of and consent for the petitioner respond so and so. Yes,
We have mentioned the 34 also. 34.
44 also, 34 there.
Okay.
Acha, put 34 and 14. Yes.
Daily list for orders, item 1.
Yeah, it is. Herein, my lord, I pay for 4 weeks time to file my affidavit and reply, my lord. Respondent, my-
So earlier also, time was granted to you.
No, no, my lord. Recently they have.
No, I am from the respondent. We have filed affidavit. Earlier, we have taken time. We have already filed.
Affidavit in opposition file, no additional affidavit file.
You want to file additional?
Additional affidavit.
Like, and a concept of the petitioner, praised for and granted. How much time?
4 weeks time, maybe.
Praised for and granted time to file reply to the additional affidavit filed on behalf of the respondents. List on so and so.
Develop.
Item 2.
Please, your lordship.
Regarding substitute.
Despite the service of notice on respondent number 5 and 6
Yes.
back in 21, till date, no counter affidavit has been filed.
But
And
I was thinking, why is it in the- Why did they file the contempt in this? The division bench has dismissed the writ appeal, is it?
Yes,
This case?
so our stand lordship here is, the petitioner is.
No, that's all right. Why is this contempt case in division bench?
because lordship, it was initially the writ petition was before the division bench.
Correct. So direction is by the single judge.
No, lordship, it was by the division bench of this honorable court back in 15/3/2018.
Where is it? Let us see the operator.
The annexure A,
2018, yes, division bench order. Page number 18.
pages 17, it starts, lordship, from page 18. Five, six, Bhopal, branch, SBI, pension protect.
Page number 18. They're on. Taking the applicant. Yes, yes. Right.
We were then concerned with the disbursement of 20% additional quantum, which every judge is entitled to from the first day of the
Attaining
80th
the
year.
age of 80th year.
Yeah, first day of the 80th year.
Yes, you are from the respondent.
I am for the respondent number 1 and 2, lordship.
Who are the respondent number 1 and 2?
Uh,
Now, his reply is expected from whom?
5 and 6, lordship.
What is 5 and 6?
Manager of SBI. SBI का manager.
Bhopal branch. One is that pension processing cell. And the
Is there
other is
any,
the SBI Bhopal.
requirement to hear those SBI manager once the, is there any requirement to hear those persons?
They are the main respondents, lordship.
5 and 6.
Yes, lord.
Why, when the state, the government has already passed that order?
Here, the dispute is with regard to the revision that has taken place in the pension.
First of all, the order has to be passed by the government and then only the state, the bank is only to disperse the amount as per the orders.
That has been done, lordship.
that has been done, then
That it has been revised is, if your lordship will take up the affidavit of respondent number 2,
yeah,
that has been done, but she disputes.
that is a page.
Lordship will see paragraph 4 at page 3.
No, reply starts from which page? Counter.
Uh,
Counter of the respondent number 3. It is page 92.
92, Lordship.
Yes, which para you are referring to?
Paragraph number 4.
Oh, that with the.
Page 94.
And paragraph number 12, lordship.
Ma'am, this in counter para 4 to the counter the respondent number 2, they are very they have specified that on which date you have been the pension has been dispersed to additional pension has been dispersed
Lordship,
by the bank itself.
yes, Lordship, that has been dispersed, but
Then
in fact, during the pendency of this honorable court's judgment, which culminated in the final judgment and order 15/3/2018, the amendments had come into place. And in terms of that, on the special seal authority had come into place. And so there was a revision in the basic pension. So the revised pension of the petitioner should come to around 1,12,500 something. With effect from 1/1/2016. Lordship.
no, this in counter they have specifically said that we have already revised the pension. That para number 4. Counter to the respondent number 2.
Yes, Lordship.
That they done.
But my lord, my instruction is that the pension slips of the petitioner does not reflect that.
Either you find a counter to it because bank authorities are nothing to do. The They are simply have to follow the order passed by the authorities concerned. So in a strict sense, bank cannot be put for contempt. So you, if you want to counter that, then file counter to this reply to the respondent number 2 and 3. Then only we can.
They filed it. They filed it. Reply file.
I have already filed that, Lord.
You have already filed.
Yes, Lord.
That is at page.
No, 183.
180.
18.
Page 183, it starts.
183.
And page
Yes.
202. Para 2 at page 191, Lordship.
Ms. Chaudhary, at the moment, what is the pension amount received by the petitioner per month? Can you give us the figure?
If your lordship will see my affidavit,
Yes.
last annexure.
Can you give us the figure? What is the figure?
Uh, It's total pension is 132,751 after deductions.
So that is what is being received at the moment by the petitioner. And according to you, what should be the figure?
My basic pay should have increased
What
to
should be the figure total?
1,500. 1,12,500. That has been paid.
I mean, we have 1,32,751. He's saying it should be 1,12,500 plus 22,000. 22,000 must come to 0, 0, 0. ये मिलता है, ये मिलता है।
And that should have come from 1/1/2016, Lord.
That's right.
Yes.
So around 6,000 per month is the difference.
Yes, Lord.
Yes, Mr. Who you tell-
Lordship, so far as the calculation part is concerned, Lordship, that the AG does the calculation and covers the SSA to us, Lordship. That is how we forward it to the bank. So if there is any discrepancy in the calculation, perhaps the AG can take it up. Otherwise, they have to forward it to the central government.
They are party here.
Yes, yes.
Yes, Lord.
Yes.
Yes.
For respondent 3.
Respondent 3.
Yes. What is your stand?
Our state is, we have already, 26 April 2018, we have sent the letter to the
But they are
principal
disputing
and
the
accounts
amount
officer.
which you are disbursing. They are disputing that amount. How
Lordship.
do you, how do you
Yeah, I
respond
have
to
to
this?
take instruction from the weather calculation regarding the part of calculation. I have to take instruction. Lordship.
How much time you do?
2 weeks.
2 weeks? For the purpose of.
Okay, 1 week. Next week. Next week, any day. Lord.
Okay. When a council appearing for the respondent number 3 pays for and granted, trying to verify that the amount in lieu of pension, the pension amount dispersed to the petitioner is in accordance with the direction given by this court or not. Full stop. List on so and so. And, madam, we don't think that there is a requirement of this bank for the purpose of this contempt petition.
Noted.
We'll see to it.
Lordship,
19 to
19.
19.
Item 3.
Yes.
May I please, Lordship, this is income tax appeal.
Fine.
Earlier, the petitioners, respondent were operating their business from Guwahati. But when we were directed to serve notice, that was, we came to know that they have closed their office from here.
Yes.
Now, Lordship, we have come to know that operating from West Bengal, Lordship.
You were granted time earlier on 1310
No, Lordship, we were
to move
granted time.
appropriate application for substituted service.
Lordship, at that time, we have their address of Guwahati only. Now we have come to know that operating from West Bengal.
West Bengal.
Lordship, may I be allowed to take 3 steps on West Bengal address? Lord?
You have to furnish the fresh notices.
Yes, Lord.
Okay. Run concept.
Then.
So if you want to get the address of the respondent changed, then file the amended cost title. We'll issue a fresh notice.
I'll find necessary application within a week.
Then concept of the petitioner pays for and granted time to furnish the amended cost title with the fresh address of the respondent. List on when
After a week, Lord. After a week.
list on के बाद की date.
Much approved.
Item number 5.
Service of respondent number 7 not
Yes,
complete.
7 is the present vice chancellor of the university and his drawal of salary and allowances are under challenge. So it is requirement. Fresh steps will be taken by the matter. Oh, sorry.
See the fresh steps. लिखिए. As per the office reports, service of notice upon the respondent number 7 is not complete. Would stop. Learn it. Concept of the petitioner is directed to furnish the requisites in respect of respondent number 7 in 2 sets. One set be given, one set be sent by ordinary post and another set by sent through registered post with acknowledgement of you. Within
2 days, my lord.
within 2 days on furnishing the same, let notices be issued to the respondent number 7 returnable on 24 weeks. Given date.
Item number 6.
May it please your lordship. In this case, respondent have filed their affidavit, lordship. We want to file a reply, lordship.
Affidavit to the application, condonation of delay application.
No, lordship, it is contempt case, lordship.
I'm
They
sorry.
stated that they have complied the order, but our contention is that
So
they had
that's
not.
item number 7,
6, lordship.
6.
Yes,
Affidavit reply not filed. That now they have filed.
They filed their affidavit, lordship.
Indicate. And it concept of the petitioner has submitted that he is in receipt of counter to the contempt petition on behalf of the respondent. She placed some time to file reply to the rejoinder to the reply filed on behalf of the respondent. List on so and so.
Obliged.
Then I'm confident.
Item number 7.
As per office report dated 6/1/2024, service report is awaited in respect of sole respondent, my lord.
That is of September 2023.
Yes, my lord.
Fresh notice issued.
Yes,
Fresh
ma'am.
notice for the Issue fresh notice to the answered respondent. Requisites be filed within a period of 1 week. On filing of the same, let notice be issued to the respondent, returnable on so and so.
Item number 8.
May I appeal, Your Lordship?
Yes.
This lordship application is for condonation of delay in filing the connected lordship related appeal.
Delay of 484 days.
Lordship.
I'm appearing for respondent number 6, Lordship. By tomorrow, Lordship, I will file my affidavit in opposition, Lordship.
And earlier also the time
Yes,
was
Lordship,
granted
but,
to you last time on 15
yes, Lordship.
2023.
Lordship, respondent number 6, son died here.
Earlier also, Lordship.
She could not come, Lordship.
Last opportunity.
Lordship. By tomorrow, I will.
Last opportunity of a week is granted to the counsel for the respondent number is to file response to the condonation application. List on to and fro.
Obliged, Lordship.
Item number 9.
Matter is less to I have for delay of 1 month.
Delay of 129 days.
Yes, my lord.
Yes.
I have served the
Respondent number
5. I have filed a dust affidavit.
What is the cause for delay?
My lord, because of her illness, my lord.
What illness? Do you
My lord, I have
any documents in respect of illness at all?
Yes, my lord, I have annexed medical prescription, my lord.
That is a page.
Page 7, my lord, annex array.
Salt restriction.
Yes, my lord.
Salt restriction means a BP बड़ा हुआ.
My lord,
It's a common problem.
no, my lord. I have stated in paragraph 4, my lord.
Why have you written criminal appeal in your cause title?
My lord.
Yeah, agreed by which order? Which is the impugned order?
My lord, it is fixed on that is main manner appeal, my lord. Annex is page number 64, my lord, annex of 4 in main appeal, my lord.
Judgment dated 21st of December 2022.
Yes. My lord, the relevant portion in paragraph 17, my lord.
17.
Yes, my lord. Page number 72, my lord.
So, the London single thing is conscious of the fact And specific direction was given if the population of the general category is more than 40%. Or pattern that 40% people of the cell will belong to general category, the concerned respondent shall appoint the petitioner as Anganwadi worker in so Anganwadi center. Or in circle, if it is of the population that is covered by 40% of the people in the SC community or any other community other than the general category, and this regard respondent number 2, 3, 4 shall do the needful issuing fresh advertisement. What's wrong in that?
Malad, difficulty is that this judgment may not be, cannot be implemented because Malad, there are more than 40% general category Malad persons and more than 40% scheduled caste persons, Malad.
So
In the
more
locality.
than SC,
Yes, my lord.
community. Yeah.
So, Malad, if 40% of the general category is there, my lord, I should have been appointed. But there are 40% of SC community also. So, Malad, judgment is yet to be implemented by the authority.
But,
That is the difficulty, my lord.
how many posts are there?
Only one post, my lord.
Only one post is
My
there.
advertisement was open advertisement. They challenged the judgment, my selection. I was selected. They challenged my selection on the ground that it should have been
You belong
reserved.
to which category? You
I'm
belong
general-
to which category?
I am the general category candidate, my lord.
He wants to general.
45 is the time period. Whether it cannot be implemented, then this must.
This is the difficulty in the implementing the
You
judgment.
presumed it. Otherwise, is there any order of the government that this order can't be implemented or what?
No, my lord.
Then
Till date, my lord, I have
specific
not been
direction is
appointed.
there.
My lord, till date, I have not been appointed, my lord.
Huh?
In pursuance to this judgment,
Nobody is appointed till date.
my lord, no advertisement has been issued. I am also not appointed. If-
There is a positive direction in your favor. File a
Yes, my lord.
petition. Why you have challenged
Let
this?
the authority implement this judgment appointing me, my lord. I will be happy.
You will be happy,
My
but
lord.
at least
My lord, only difficulty is that, my lord, there are 40% each of the community.
yes.
The general category is 40%, more than 40%, and the SC community also, my lord, more than 40% in the locality. So, my lord, if first part is to be implemented, I can be appointed. The other part, my lord, if it is to be implemented, a fresh advertisement is to be issued.
But then it is for the state to raise a grievance against the judgment. Why you have come here? We don't understand.
Because, my lord, I have
There is a positive
the
direction in
I
your
have-
favor against the 40% general category pattern is 40% general category, then you should be appointed.
yes, my lord, but till date, my lord, I have not been appointed. I am a selected candidate,
File
my
a
lord.
contempt petition, sir. Why appeal? We don't understand.
I-
You are
I
having
approached
your
the
order in
authority.
your favor and still you are challenging it.
My lord, I approached the authority. They said, my lord, this because of the other part.
Where is that? Which communication the
In
authority said?
writing, there is nothing, my lord.
The writing, then file a contempt petition. Either they'll file their response or they'll implement that order. We don't understand why you are, how you, why you are
And
challenging this
agreed by
order.
the later part of the judgment, my
The
lord,
later
but
part of
40%.
the judgment should be the grievance of the state, not of the petitioner.
I'm a selected candidate, my lord. I have not been appointed till date, my
Mr.
lord.
Saikya, the
Yes.
learned single judge has only said that carry out a proper survey. And if you find that the population 40% plus is of general category, then you should be appointed.
My lord,
If it is otherwise, then it will go to the SC community
my
candidate.
lord.
What is wrong with their order? You have waited for more than 4 months and then you are coming challenging this order. If they have not carried out the direction, then it's a case of contempt, which my lord, the Honorable Chief Justice is saying. Why should they modify that order after lapse of so many days?
My lord, the judgment.
It is the order of
operative part-
2022.
Operative part of the judgment says, if there are 40% of the general category, the petitioner should be, the appellant should be appointed. And the other part says, if there is 40% of the SC category population, then it should be open advertisement.
Yeah.
But both the category has 40%, more than 50% inhabitants in the locality.
You are
So
assuming.
that is for the state to raise this grievance.
That clarification, Lordship may give an observation that if there is
So
40
why
more than
should we get this observation? The order is already there. And we find there is no illegality in that order.
This order is not implementable, my lord.
So implementable, that then the state should come here that we can't implement this order, please modify this. Why you are coming? I don't understand. We don't understand.
Malad, see,
Why you are challenging this? The order is in your favor and you have filed the appeal.
Malad, I am a selected candidate, Malad. I have not got the fruits of my selection as well as the judgment.
Okay.
What? Should we go into merit? Mr. Saika, take the correct reports.
You seek your instructions, otherwise we don't find any reason to condone the delay. And on merits also, we are not convinced. That
No,
you
I'll
are
take it.
supposed to challenge this order.
My lord. I'll take instruction, my lord. I'll take instruction, my lord.
When?
Next week.
Okay. Mr. Twenty-four, place some time to complete his instructions, list on 20. Next week we did it.
Oblige, my lord.
Item number 10.
May I please, your lordship. This is a leave petition, my lord. I'm preferring this leave petition because for allowing the applicant number 1 form, my lord, to join hand with the applicant number 2 in preferring this appeal, my lord.
And the applicant number 2 in the appeal.
Yes, my lord. If the applicant number 2, my lord, is a respondent in the writ petition, my lord, but the form, my lord, to who is the work order has been issued, was not arranged as a party in the writ petition, my lord, my lord. So, my lord, this is leave petition, my lord.
At the time of decision of the writ petition, the work order was issued or not?
Yes, my lord. Order was being issued, my lord.
Then why you are not moved in application for including that firm as a party before the single judge?
My lord, the proprietor, my lord, who was the applicant number 2, my lord, he did not, my lord, he didn't appeared, my lord. Because of the wrong advice, my lord, he did not appear, my lord. But apparently, my lord, the order that has been passed by the learned single judge, my lord, is purpose on the ground that, my lord, the main subject, my lord, the authorization letter or certificate, my lord, which is required to be submitted during that, which is a condition for tender, my lord. That authorization certificate of the writ petitioner was, my lord, not in consonance with the scope of the work, my lord. So, my lord, basically only because he has the authorization certificate and my authorization certificate was submitted after that last date of the submission of the tender, my lord. Even though the railway authority has allowed me in that aspect, my lord, but my work order in the underway, it was cancelled, my lord. I was running the work, my lord, and in the affidavit it was also mentioned, my lord, that since, my lord, the appellant here, my lord, he is the L1 bidder, my lord, and the writ petitioner is L5, and difference between both the bid amount is 22 lakhs, my lord, and the work value is 33 lakhs, my lord. So work has been allotted to me, my lord. So this financial aspect of the matter, my lord, has not been taken into consideration, my lord.
Mr. Alam, your prayer is to allow you to join another applicant to
No, my
file
lord.
appeal?
No, my prayer is, my lord, since my form has been allowed, award the work, my lord.
It is a proprietorship form.
Yes, my lord, it is a
Proprietor is automatically a part of it.
Yes,
Proprietorship form doesn't
Yes.
have any independent entity.
my lord. But yes, there is that, my lord. Yeah.
Why have you filed this IA?
It has been filed, my lord. May I pray, my lord, this leave may be granted, my lord, for the appeal may be registered, my lord. My lord, kindly grant me the leave, my lord, so that I can consider it.
As my brother has pointed out,
Yes,
the
my lord.
need of joining you when you are the proprietor and you are the appellant.
The form, my lord, yes.
It is the question of firm.
But-
The partnership firm, you would have understand.
Yes, my lord. That
If
is
one
there,
of
my
the
lord.
partners preferred the appeal and the other partner or the firm wants to join the as a area of the appellant, You could understand why.
But
Okay, the
leave may be granted, my lord, in the appeal, my lord, let it, my lord. Leave may be granted, my lord. In any case, my lord, leave may be granted, my lord. Because all the work order is in the name of the firm, my lord.
The matter comes upon for consideration of the application preferred on behalf of the appellant with a prayer to allow the firm to whom the appellant is the proprietor, firm, to whom the appellant is the proprietor as respondent number, as appellant number 2 in this appeal. Full stop. Having gone through the application and the nature of the dispute, we allow the petitioner to pursue the present appeal on behalf of the firm also. Applicant, we allow the applicant to pursue the appeal on behalf of the firm also. With these observations, the application IA number so and so is disposed of.
My lord. The appeal may be. Admission.
Yes, what do you want?
No, I am for the railways, my lord. Railways respondents, my lord.
You want to, have you filed the,
No, my lord,
your pleadings are complete now?
no, my lord, it will come for admission, my lord. IA is.
I have disposed, my lord. It will be numbered now, my lord.
This is writ appeal number so and so on point, date बता दें आप कौन सी date को चाहिए आप?
Next week, what, my lord?
After 10 days को ये date.
Oblige, oblige, man.
Item 11.
It is a lordship, this I for condition of delay lordship, and as per office note dated 11/1/24, service report is awaited lordship. And notice was issued on 8/1/24 lordship.
Service upon the respondent number 3 is not complete.
Yes, lordship.
There is a delay of 2,300 days.
Yes, sir. There's a review pending lordship.
Hmm?
Review petition was pending.
Review was pending. As per the office report, service of notice upon the respondent number
One.
is not complete. Respondent number 1 is
One.
not complete. Let fresh notice be issued to the respondent number 1. Returnable on so and so.
Obliged.
Item number 12 for admission.
May I plead the lordship? My lord, the appellants are mainly aggrieved by imposition of penalty, the cost of 10,000 rupees while preferring the review petition, my lord. The facts of the case is that, my lord.
On the mighty state, 10,000 rupees.
Yes, my lord.
Your announcement of the amount.
No, my lord. Because, my lord, the petitioner. No, my lord.
So you want enhancement?
No, my lord. The petitioner exhausted the legal limit.
50,000.
No, my lord. The petitioner exhausted the legal.
We imposed the cost of only 10,000 on the mighty state. Yes, it's
because
leading to your state status.
Because, my lord, the appellants exhausted the legal remedy available to them, my lord. Because, my lord,
there was an agreement before the learned single judge.
that was between the private respondent and writ petitioner. Because that.
No, you just see.
Yes, my lord.
See the order.
Yes, my lord. Page 27, operative portion, my lord. Because, my lord, in the writ petitioner. Yes, my lord. The order starts at, my lord, page 25, my lord, and operative portion at page 27, my lord.
Has the amount been deposited?
No, my lord, there is a stay order by this honorable court, my lord, regarding the imposition of cost, my lord.
The order has been implemented.
My lord, now, my lord, a speaking order has been passed by the department, my lord, in respect of the candidature of the petition, my lord. Petitioner, and regarding that speaking order, they have filed a separate writ petition, my lord, which is pending adjudication before this honorable court.
You pass an adverse order against the.
Yes, my lord. Because, my lord, if your lordship peruses the advertisement at page 23, my lord. At page 23, if your lordship peruses the advertisement, my lord, the criteria stipulated in the advertisement, my lord, the writ petitioner did not fulfill that, my lord. And that fact was not revealed in the writ petition, my lord. Because in the writ petition, they only contended that only because of timers, my lord, he has not been appointed, my lord. And department also did not get the opportunity to file affidavit in that case. Only on that condition that, my lord.
So the other side is already
Yes.
there.
Yes, my lord.
Yes.
For the respondent number 1,
Yes.
Lordship, initially I had filed a writ petition only on the ground that the appellant had not offering the appointment me showing a reason high of mark. After filing the writ petition, the private respondent appeared and filed no objection, and accordingly, the honorable court passed the order to consider my appointment.
Right.
Thereafter, I had filed contempt petition. After filing contempt petition, the appellant had preferred a review petition after 1 year back.
That review petition is dismissed with cause.
Dismissed with cause.
Yes.
Supporting portion, page number 35.
Yes. Page number?
Page number 35
Yes.
from the middle portion, the land counsel for the writ petitioner also appears to be correct in contending that the issue of eligibility, the requirement of having medical record officer training cannot be raised, as it was not possible to all for any candidate to fulfill the said condition, as the same was introduced even less than a year before the advertisement.
Mr. Counsel, they are not challenging the order on merits. They are simply saying that the imposition of cost by the learned single judge upon the state was not necessitated because they were not heard before the learned single judge by passing the order in the writ petition.
Lordship, the appellant had appeared in presence of the appellant.
Is there any concession?
Yes, a fair submission. Lordship, page number 27.
The submission was only
Page number
because.
27.
Yes, madam.
Where is their concession? Where is the concession of the state? Maybe it was there, but where is the concession of the state? In this order, 12/10/2020, where is the concession of the state? Your presence is there.
Yes, Lordship.
That's why only they filed the review petition.
Lordship is fairly submitted before the.
Where is that?
Page number
show.
27, para number 4, Lordship.
Para number 4
4. I am reading it.
of the order dated 12/10/2020 or the review order?
12/10/2020.
20.
Yes, read.
Lordship, para number 4, Sri Burman, the Land Council for the petitioner, submits that in view of such affidavit of the respondent number 5, there should not be any impediment in considering the case of the petitioner. Sri D.P. Bora, the Land Standing Council, has also fairly submitted that in view of such categorical stand of respondent number 5, the deponent may be directed to consider the case of the petitioner.
Did you really make that submission before the legislature?
My lord, I made the submission on the context that because writ petitioner contended before the honorable court that, my lord, only because of the time marks between the writ petitioner and respondent number 5, the appointment was held up, my lord. So the respondent number filed one affidavit saying that he has already got some another job, so there he doesn't have any objection if the writ petitioner is appointed. Only to that extent, my lord, if your lordship peruses that portion, only to that extent.
So, cost is another matter, we'll see, but then why are you not appointing him? You have passed the advice.
Because, my lord, if your lordship peruses page 23, my lord, annexure 1, my lord, the advertisement, my lord, page 23 and 24, my lord. Advertisement, my lord, the impugn advertisement at page 23, serial number 6, medical record officer. The petitioner for this post, my lord. So minimum educational qualification is graduate in arts, science, commerce from a recognized board or university with medical record officer training from recognized institute. Now, if your lordship peruses page 24, it reflects that, my lord, the writ petitioner, neither the writ petitioner nor the private respondent, they did not have this qualification, my lord. And that fact was not Now, if your lordship peruses page.
Lordship.
And now they have considered your case and they have rejected your candidature or whatever the no favorable order was passed, and now you are in writ appeal before this court after that.
They have filed separate writ petition.
That writ petition is pending.
Yes, my lord.
Pending.
Take well, easy the cost.
Yes, my lord. And regarding the cost part only, my lord.
Lordship,
Mr. Bora, one thing, ordinarily the appeal is not maintainable,
Yes, my lord.
but in a review, imposing cost, doubtful.
Yes, my lord.
Therefore,
Yes, my lord.
Ineligibility.
Yes, my lord. I am with the limited part of the imposition of cost only, my lord.
Yes, what do you want to say?
Nothing, Lordship,
No, I think so that any grievance remains now.
Lordship, the appellant said that I have suppressed my qualifications.
That is altogether different thing. That will be, that would be adjudicated in the writ petition pending.
Yes,
Here only the
pending.
question is imposition of cost. Click here.
Yes,
This writ appeal is filed by the state, being agreed with the order dated 24/7/2023, whereby the learned single judge, while dismissing the review petition filed by the state, has dismissed the same while imposing a cost of rupees 10,000 with a direction to deposit the same in the name of Guwahati High Court Lawyers Benevolent Fund within a period of 2 months. Would stop. Learned counsel, the appellant has submitted that the writ petition filed by the respondent was decided by this court on 12/10/2020 on the basis of concession given by the counsel for the respondent number 5. It is submitted that the state has only agreed to consider the case of the respondent in the given circumstances, and there was no concession on the part of the state that the respondent would be provided appointment on account of concession given by the counsel for the respondent number 5. It is submitted that the state has filed the review petition mainly on the ground that the respondent is lacking qualification for appointment on the post of medical officer,
Medical record officer.
medical record officer. However, the learned single judge, while dismissing the writ petition filed on behalf of the, while dismissing the review petition, has imposed the cost of rupees 10,000, which cannot be said to be justified in any manner. You could stop. It is further submitted that pursuant to the direction given by the learned single judge in the writ petition, the candidature of the petitioner is already considered by the state and the same has been rejected. And against the said rejection order, the respondent has already preferred a separate writ which is pending consideration before this court. Stop. Learned counsel for the respondent has opposed the appeal. Stop. Having heard the learned counsel for the parties and after taking into consideration the facts and circumstances of the case, particularly the fact that there was no concession on the part of the state at the time of passing of the order dated 12/10/2020. We are of the view that the cost imposed by the learned single judge upon the respondent, upon the state, while dismissing the review petition, is not justified. The same is therefore, the cost is therefore made easy. The writ appeal is disposed.
Deeply applied.
Item 14.
Yes.
Malo, in this case, Lordship, I basically challenge the Mala, the proclamation of sale, my lord. And the Mala valuation they made before issuing the proclamation of sale, my lord. Now, in this case, my lord, it is an admitted fact that, my lord, I'm unable to pay the loan, my lord. Accordingly, it has become NPA, my lord. That is an admitted fact. I'm not in. But what I'm on that, my lord, the valuation of the property, my lord. Whether the property was properly valued or arbitrarily valued, my lord, because it's my property after all, my lord. So there should be a proper valuation before issuing the proclamation of sale. So therefore, my lord, if your lordship now look into the sequence of evaluation, my lord, actually after when we taken the loan, my lord, property was valued in 2015, my lord. That was around 1 crore, my lord. So it was never the less than 1 crore, my lord. So when they issued a notice under section 13.4, we assailed it before the DRT, my lord, and that is pending. Then they preferred an OA, my lord, for recovery.
In that proceedings,
Yeah.
you also raised this question that it is the property is undervalued.
My lord, they filed, that was not known to me then, my lord. When they filed an OA before the DRT for recovery of the matter,
Yes.
we filed an written statement. There we raised the point, my lord.
You have raised upon,
Asal-
and that is pending consideration
This is
before
both the
DRT.
petitions are pending consideration before the DRT.
Then, yeah, not the arguments before the DRT. Why should we interfere in this?
My lord, only the thing is that, my lord, now they issued a sale proclamation to sell our property. Though, my lord, both the proceedings are pending before the DRT, my lord.
Then you get it decided from the DRT. Why should we interfere in this 226?
My lord, because of the arbitrariness on their part.
Arbitrariness or whatever it may be, the Honorable Supreme Court in repeated judgments have deprecated this practice that why the courts are interfering, the high courts are interfering in Article 226.
My lord, because,
And they have in so many words,
my lord,
then
my lord, only the thing is that there, so far there's an exception is there when there is an arbitrariness, which one hit by Article 14 of the Constitution, my lord.
Mr. Ghosh, it is not valuation, it is the reserve price.
Reserve price, yes, my lord.
Somebody
Reserve
can
price
buy it
based
for
on
2 crores
valuation.
also. Somebody can buy it for 2 crores also.
Oh, my lord.
Their job is to fix a reserve price, which is always less than the market value.
My lord, what I'm trying to,
So if you still have a problem with that,
my lord,
the competent forum is to decide it. To that extent, perhaps we can agree. But
My lord,
we can't give the decision on.
my lord, what I respectfully submit before your lordship is this, my lord. My total loan amount is, my lord, 1 crore something, my lord, 1.10 crores, my lord. Now, when they filed a valuation report before the DRT on 2021, property was they valued the property as 1.27 crores, my lord.
yes,
Now, before my lord issuing the proclamation of sale, they have in their affidavit they enclosed to a valuation report, my lord. Now they reduce the value of the property as 70 lakhs.
80 lakhs.
80 lakhs. And on the basis of that, reserve price was fixed, my lord, of 54 lakhs.
Basis of that, you consider on the basis of that valuation of the property, they fix the reserve price. My lords have rightly pointed out that it's only a reserve price. They may or may not
My lord, my appreciation,
accept the
Yes,
auction
my-
proceedings or even for 2 crore.
my lord, my question is this, if the base price is 54 lakhs, my lord, if anybody offered 55 lakhs, he can get the property. I'm just on that, my lord. Then the rest of the amount I have to pay.
So ultimately, what is the jurisdiction in Article 226 of this court? you
Lord,
satisfied?
I am on the valuation of the property. This proper
Valuation of
arbitrary.
the
My lord.
property, we are not experts
My
to
lord.
value the property.
What I said, my
Not
lord,
expertise
let
with
them.
with this code.
Yes, I understood, my lord. That part I know, my lord.
Then-
What I respectfully submit, my lord, let them properly value the an independent valuer. Everything is a bank valuer, this, and let them go for a sale notice.
That is.
Because, my lord, the period of proclamation is already over. Sale notice, period of sale notice is already over, my lord. So that I am also not, my lord, prejudiced anyway, my lord. Let them get it a proper valuation by an independent valuer, not by bank valuer. And then they proceed, my lord. I have no objection.
এটা ট্রাইব্যুনাল পরে হয়েছে পহলে এটা ট্রাইব্যুনাল রিপোর্ট হয়েছে গভর্নমেন্ট গুলো বললাম তো আমার কাছে নাই
So you have already raised this ground before the DRT in separate proceedings that the property is the property is undervalued.
My lord, this valuation report has been submitted after the OAS filed by them. It is of 233 recently. I have received it just.
So you have filed your objection regarding that before the DRT.
My lord, this OAS filed in 2021 by them, and the valuation report is of 2023.
Fine.
My lord.
Now, just now you have submitted that.
No, my lord. Now I have checked, my lord. I'm sorry, I have checked, my lord. Report of is 2023, my lord, which I came to know from their affidavit in opposition. They get it valued in 2023 before issuance of the proclamation of sale. And 2022 DRT proceeding in where they filed the OA, they filed the evaluation report that my lord will find. Just I'll take my lord to my lord. May I please? It's 8th page, my lord, 92. 92 of the awarded petition.
Yes, yes.
Your lordship, they have filed surface application against the possession taken by the bank
Yes.
in the year 2021. In that case, we have already filed our objection. And fact of the case is that they are admitting availing loan from the bank. They are admitting creation of mortgage. But they are saying that there were two partners, that they will pay 50% and rest they will not pay. It is their stand before the DRT. Since there was no stay by the DRT, bank has proceeded further to sell the property. When the property was put on sale, as per provision of the Surface Act, bank has taken fresh valuation of the property. When the fresh valuation of the property was taken, then there was 20% deviation from the earlier valuation. So bank has taken second valuation. In that valuation too, the same price was given. So bank has put the property on by making average of the two valuations taken from the two
What
values.
is this formula? You can't say.
That is the result
Where
price.
we
my
got
lord.
this formula?
My lord, here we have taken fresh valuation.
First
Fresh
you
value.
have the valuation of the property and then you got another valuation.
Yes, sir.
And then you
Yes, sir. At the time of auction sale, we have taken two valuation. And that valuation was near about the same. That valuation, in paragraph 13, I have explained this. What are the valuation at the time of putting the property in sale? We have taken that valuation.
That is why I want the valuation, my lord. They have taken average of that and fixed the base price of 54 lakhs.
Yes, sir, the valuation was 70 and the reserve price is fixed.
After they filed their response to that in the DRT. Have you filed any objection regarding this valuation call of the property?
My lord, we just received it recently, my lord, with their affidavit, two valuation report. That was not before the DRT, even they did not
You
file
have
it.
raised
before
this
that.
question before the DRT or
No,
not?
my lord.
You have not raised.
Raised because we have received it recently, my lord, just now. Along with
We
the
grant you the liberty to raise this question before the DRT.
my lord.
And the DRT, and will also request the DRT to decide the
Yes, that also one, my lord.
way within stipulated time.
Otherwise, act provides for, my lord, early disposal of all these DRT proceeding, my lord, under the surface as well as the.
Yes, Mr.
But
Do you have any objection?
all till
The
then, my
matter
lord, they
is
should
fixed
not
on
proceed with
15th
the
of this
same.
month. It may be taken there.
Well, pass an order that possible objection he may raise
Yeah.
regarding the
Yes, yes.
valuation
Yes,
of the
ma'am.
property
Yes, ma'am.
before the DRT in the pending proceeding.
They could have raised
And,
this before the
The
DRT.
DRT is requested to decide the same within a period of the till then this interim order passed by this court. will remain
That
in
auction
balance.
sale has failed now.
Huh?
That auction sale has failed. So
That is over.
But the
that is
stay order was
over.
there.
So
But they should not take coercive action in the meantime. That is the thing, my lord.
But
the-
despite
the
that,
matter-
despite this stay order, you proceeded with the auction.
no.
In the meantime,
We have
the
not
auction
proceeded.
proceedings of secured assets.
We have not
which is
proceeded.
scheduled to be held on the shall remain state.
We have not proceeded.
Yes, my lord.
The case is fixed on 15/2.
It appears because the valuation is.
In the DRT, the case is fixed on 15/2, 15th February.
Okay. This writ petition is filed by the petitioner, essentially being agreed with the action of the respondent bank of fixing the reserve price of the secured assets, contending that the market value of the secured assets is around 1 lakh. कितना बता रहे हैं आप?
1 crore 27.
Golf course 27, my lord, but they are valuation.
1 crore?
That was in the year 2021.
21.
It must have been now increased.
No,
Property का rate
there
increased.
was
They have
flood
videos
in that
more than
area. There was flood in that area. That's why the value of the property has been drastically reduced. At present, in Silchar area, in the year 2022, there was a flood. So the value has been decreased.
Yes. क्या लिखा है? Is around 1 lakh,
1 crore.
1 lakh,
1 crore 27.
1 crore 27 lakhs.
Right.
Whereas the bank has fixed the reserve price of the said property as 54.22 lakhs. Would stop. The facts which are not in dispute that that the respondent bank has advanced a loan to the petitioner. However, the petitioner has failed to repay the said loan as per the schedule, and therefore proceedings under the This is your Securitization Act of under that, even referred as Act of Securitization Act has been initiated against the petitioner under section 13 and the other relevant provisions. Full stop. In that process, the respondent bank has issued a sale notice or auction notice, has published the auction notice wherein the reserve price of the secured assets is mentioned as 54.22 lakhs. Being agreed with the same, the petitioner has approached this court by way of this writ petition contending that the market value of the property is around 1 crore 27 lakhs, whereas the bank has fixed the reserve price of the secured asset for a very less amount, that is less than 50% of the market value of the secured assets. Full stop. Reply to the writ petition is filed on behalf of the respondent bank wherein preliminary objection regarding the maintainability of the writ petition is raised. It is the case of the respondents that against the proceedings initiated by the bank, against the proceedings initiated by the bank, the petitioner has a statutory remedy approaching the DRT, Debt Recovery Tribunal under section 17 of the SARFAESI Act. It is contended by the London Council for the respondent bank that as a matter of fact, against the proceedings, as a matter of fact, the petitioner has already approached the DRT by filing DRT and the proceedings initiated at the instance of the petitioner before the DRT are pending consideration. And in such circumstances, this writ petition is not at all maintainable. Stop. Having learned concept of the appellant has submitted that though the proceedings before the DRT initiated at the instance of petitioner is pending consideration, but the question regarding the valuation of the secured asset has not been raised before the before it, as the respondent bank has produced the valuation reports before the DRT recently in the year 2023, whereas the DRT procedure where the proceedings before the DRT are pending since 2021. Full stop.
May I please hear this?
Yes.
Note in the DRT, before putting the property in auction sale, we have taken fresh valuation. Note in the DRT.
You have taken
Fresh valuation of the property before putting the property in sale.
We'll get it done. We'll get it done in the final order. Stop. Having heard the learned concept of the parties and after going through the material available on record, we are of the view that the present writ petition filed by the petitioner being agreed with the action of the respondent bank, whereby it has fixed the reserve price of the secured asset, is not at all maintainable and is not maintainable, as the petitioner as a statutory remedy of approaching the DRT against the action of the respondent bank in the as per the provisions of Securitization Act. Under the provisions of the Securitization Act. Stop. is also to be noted that the petitioner has already initiated proceedings before the DRT and the same are pending consideration. Stop. In the interest of justice, we grant liberty to the petitioner to raise objection regarding the action of the respondent bank of valuing the property, valuing the secured asset within a period of 1 week. 1 week में आप objection raise कर दीजिए.
My lord, he is from Silchar, maybe 2 weeks, my lord. That will be better. He will be coming
2
from
weeks or 3 weeks.
3 weeks, my lord. I leave it to lordship, my lord. I leave it to your lordship, my lord.
सर ये
I-
15
I
तारीख
say
को
to-
फिक्स है केस 15 तारीख को फिक्स.
Only on 15th.
Yes.
By 15th, you file your objection. File your objection.
My lord, one correction is they have also filed an OA, my lord. That may be also considered
For what?
for realization
For
of
recovery.
dues from us.
Okay, that's both are the.
Both are pending.
Both.
दोनों एक साथ hearing का एक साथ में.
File your objection in your
Both,
petition.
yes, my lord. That may be indicated. Otherwise, they say there is no objection in OA. Ah.
Within a period of 1 week.
1 week.
Within a period of 1 week from today, full stop. If any such objection is filed by the petitioner, we expect that the DRT shall consider the same along with the other grounds raised by the petitioner in the pending proceedings.
My lord, that is SA number 79 of 21.
Proceedings may-
My lord, both the proceeding.
In the pending proceedings, full stop. We request the DRT to decide the OA filed by the petitioner as well as the bank within a period of 6 weeks from the date of production of certified copy of this order till the OA filed by the petitioner and the bank are decided by the DRT Guwahati. The interim order passed by this court on 19/9/2023 shall remain in current.
Obliged, lordship. Obliged.
Yes.
Item 15.
Wait, your lordship. Your lordship, may kindly peruse the order dated 21st of December 2023, when the matter was moved. Leads the matter on 8/1/2024, enabling the respondents hearing to appraise the court as to whether the person to the postal communication of the speaking order dated 13/1/2017 that was sent by registered post, the postal receipt of which was placed before the London Central Tribunal, Guwahati, was duly delivered to the addressee concerned as specified in the said postal receipt or not. Thereafter, my lord, 2 more dates have been given. On 22nd of January, last chance was given to them. The issue here is the petitioners before your lordship, 55 in number, they are casual workers in the railways. They were engaged from time to time for quite a long period, and thereafter they were disengaged. But other similarly situated persons, 194 in number, they were re-engaged again. So they prayed, initially their prayer was that they should also be considered for re-engagement. That was the prayer. There have been quite a number of litigations earlier, but
Why
what
is this
happened, my
before the
lord?
division bench?
My lord?
Why is this matter before DB?
Before against the order of the CET, my lord, it has to be a division bench as per my lord L. Chandrakumar's case.
Against the order of?
Yeah, CET.
So, counsel, will you produce that information?
My lord, pursuant to the order dated 21/12/2023,
we approached the postal department, but they apprised us that they are unable to, they do not maintain after such documents after 3 years. But even though we have submitted another to the Postmaster General, my lord. But
But till date, you are not in receipt of any information regarding that.
not receiving, my lord, because it is 7 years old, my lord. But the postal receipt, my lord, at page 354, postal receipts. The speaking order dated 17/1/2000, 2017 was issued.
One of the issue here is very simple, my lord, so far as the impugned order is concerned. This honorable court directed the petitioners in a writ petition against an order of the CAT earlier that you should file representation to the railways and they'll dispose of the representation with a reasoned order. That order was passed on 1/3/2011, that is at page 139. So when nothing was done, they have again approached the tribunal by filing an OA. That OA has been dismissed as time barred because of the fact
When this court issued a direction to consider a representation,
that was on 1/3/2011.
1/3/2011.
That order, your lordship,
as per you, the respondents have not acted upon that representation.
Yes.
Then you approach the OA, the CAT when?
That was in 2022.
It's naturally, it's an inordinate delay.
No, in fact, my
Immediately
lord,
when this court has granted time in the year 2011 to approach the respondent railways, and if they have not done anything for last 10 years or more than 10 years, you are not supposed to again approach this court and within a reasonable time.
no, that is true, my lord. But your lordship, what happened in the meantime? They early filed another OA, and OA at page 10184.
We filed another
They
OA.
were not sitting.
They it's again filed
Another OA.
agreed by what?
Because, my lord, the representation was not considered. That your lordship will find at page 184. The operative part, your lordship will get. Judgment starts at page 190.
This is in the year 2016.
Yes, my lord.
What happened in that?
In that, my lord, the direction was then.
The spending of the rejected respondent to vary out the direction as above within a stipulated time.
Fine.
And then again you waited for 6 years.
True, my lord. They are, my lord, the casual workers in the railway. No, but the delay, no, but the ground on which the petition has been rejected, my lord, there, if your lordship kindly sees the impugned order.
You were engaged in which year?
My lord?
You were engaged in which year? These laborers were engaged by the respondent railways within which year?
Not me, my lord. Not me, my lord.
I'm sorry, sir. I'm not. This.
No, your lordship is asking where they were engaged.
Yes.
They were engaged from up to 1979 to 1990.
1979 to
1990, yes.
And
some of them may not be, my lord, now interested. I don't know.
1990.
Yes.
Then for the purpose of regularization or whatever it may be,
Yes.
you approached this court in the year 2011.
No, my lord, we approached this court in 2006. The first OA was filed in
2006.
2006.
That is after your disengagement with the railways, 1990 and 2006, 16 years. And
because in the
2006
meantime,
petition
because
was decided in 2011.
true, because one of the other similarly situated persons were engaged in 1992, and we
Ultimately, there must be some answer. 1990, it's almost 30.
No, what
3 years.
what I
And
improved.
after 33 years,
What I implore your lordship to go to the impugn order, my lord, whether that's impugn order. If
Some of the laborers may have attained the age of 70 years.
some of them may have, my lord, that's.
Some of them,
I don't
I
know.
think so, have gone.
They may not be interested also, but they always go for a screening. It's not that, my lord, just they're re-engaged automatically. Now, if may I draw your lordship to the attention to the order of the tribunal, which is impugned here,
Yes.
that your lordship starts at page 319. May I read, my lord, page 320? The respondents have raised a preliminary objection on the ground of limitation as the impugned order is of 2011 and the applicants have filed this instant way in 2022. The query your lordship has raised. Further, during the course of hearing, Mr. P. Dasgupta, proxy counsel for Mr. So-and-so, learned additional CGSC for the respondents had drawn our attention to the speaking order dated 13/1/2017, passed by the Chief Personnel Officer, Administration General Manager, so-and-so NF Railway, in compliance with the direction passed by the Tribunal on 19/8/2016 in OA number such and such, as well as the postal receipt, Annexure R3, showing the communication of the said speaking order dated 13/1/2017. However, the learned counsel for the applicant has submitted that they have not received the said speaking order. Now, thereafter, paragraph 5, it is noted that the prayer of the OA, prayer in the OA of the applicants have challenged the impugned order dated 25/10/2011 issued by the Divisional Railway Manager Lumding, even they had earlier approached this tribunal in 2016, which was disposed of by the order dated 19/8/2016. And in pursuant to the said order, the respondents, after granting personal hearing to all the applicants, had passed the speaking order dated 13/1/2017, and they communicated the same through postal service, which is evident from the postal receipt as enclosed to Annexure R3 in the written statement. Therefore, the applicants cannot claim that they were not aware of the speaking order. I am, my lord, agreed by this part. In view of the above, we do not find any reason to entertain the MA for consideration of delay. Now, my lord, your lordship.
The order dated 13/1/2017.
13/1/17 order was placed in the written statement, and the written statement was filed on 6/4/2023. That is the date of the knowledge.
13/1/17 is the copy of that order is on the record.
Copy of that order they have, my lord, filed in the written statement. That is on record.
Which page?
My lord, that has been filed in an additional affidavit. Initially, by mistake, we did not file the written statement. In the additional affidavit is there, my lord. It's on record.
Where is that? Page number?
It will be, my lord, page 350, 348. 348. 348. They have passed the reasoned order, but that was not communicated. And they came to know only when the written statement was filed on 6/4/2023.
Mr. Chaudhary, just wanted to ask one thing. what is the relief your clients are seeking in this writ petition?
They should be considered for re-engagement. That is the main prayer, my lord.
Is there any time age limit for doing so?
My lord, they must have, my lord, they have to we have to go for a screening, my lord. After the screening only
No,
they'll decide.
What I'm saying is.
Yeah, no, sir. Some of them.
Engagement under a government, central government department, there must be some age criteria, is it not?
They should be, my lord.
So going by the prefatory facts, it is apparent that they have already surpassed their age, leaving aside other things. And then the last order 9/12/2016 of the learned Central Administrative Tribunal gives 3 months time to pass the speaking order.
Yes.
Till 2022, no steps was taken, nobody assuming that it was not communicated. The petitioner also did not make any.
True, my lord. I agree to that.
No, why we are saying is, you see, unnecessarily pushing and prodding claims.
Only relief that the petitioners can get, my lord, even if your lordship remands it back also, only relief is that they should be considered.
Supposing the.
Even though, sorry, sir. Yes, sir. Even though you're relieved that they have considered it in this order dated 2017, a hearing of the application on 9/12/2017, and thereafter they have passed the speaking order.
Yes.
What's wrong with this order?
In the speaking order, if your lordship see the ultimate the decision on which they say that their cards are fake. Their cards are the penultimate paragraph.
Their cards are fake.
Fake. That is the finding.
We go into all this,
No,
whether
your
they
lordship.
are fake or genuine.
So your lordship need not go into that, my lord.
Yeah.
But then this finding, my lord, they are agreed by primarily that now, my lord, at this stage, because they said that those are not genuine. Last finding, your lordship will find. Okay. 353. They say, my lord, they're fabricated. Fabricated is the word they have used.
What they have said?
Fabricated.
No, sir. Can we consider this last operative report?
Operative part 353. As such, after
In view of the above, considering the facts in that in spite of being clearly advised to come prepared with for adducing evidence and full documents to establish that the applicants could not submit any documentary evidence with regard to their engagement, discharge as casual level, nor any evidence to show that they applied within the cutoff date that it so and so, after considering inclusion of them in the supplementary casual labor register. As such, after considering the above and facts and material on records, rules and instructions regard to the casual so and so, the recommendations finding of the committee constitutionally, they said after hearing the applicants, I am the considered view that applicants have never worked as a casual laborer. The organization and cards submitted by the applicants are fabricated and cannot be considered as genuine according to the claim of the for regular absorption in railway cannot be considered and hence rejected. What's wrong with that, sir? What is the material before us, or what is the material you have produced? Can these documents were genuine and not fake? It's a finding of fact recorded by.
My lord, this order is not under challenge in the way the challenge was. My lord, I am.
Now,
I understand.
ultimately, you are agreed to by this order. Suppose we condone the delay, then also, what will happen?
Maybe, my lord, they may be able to produce the documents. My lord, I am doing this as pro bono, my lord. I have seen these, the young, my lord, some of them are within age.
Yeah.
And they want a consideration that.
Consideration, they've already been considered and rejected.
No, but then, my lord, that was not communicated, therefore.
Even though it's not communicated, you just show us. We are now, despite that, even they have not communicated, we are going to examine we are ready to hear this examine the validity of the order dated 3/1/2017 here.
True, my lord. Then in that event, your lordship has to give an opportunity to place the documents, my lord. They have.
Sir, now it's an unending process. Earlier also, a writ petition was disposed of representation, then representation business. In fact, with this 2011 writ petition, you were granted liberty, and in fact, that was what I feel that was not proper.
My Your Lordship, I understand that.
2011, the court has said, "Okay, go dispose of, decide representation and you move and representation will decide that. At
Your
that
Lordship-
time, even your claim was very stale.
On equity, Your Lordship will see, my lord, the
Equity-
startup from where these
Equity is
persons
there,
come.
but there must be some limit for equity.
It's not that, my lord, they're asking that.
Amending process है. Again, we'll grant, okay, ठीक है, now we'll condone the delay and quash the order of the cat. And then we'll ask, you examine the validity of this order dated 3/1/2017. Again, it will take around 4 years. Or 6
Maybe
years
I
or
did-
10 years, and again you will come here, now this is what the, there must be some end to it. There must be some end.
Only thing is, my lord, they are asking for some consideration. Otherwise, my lord, why should they be fighting this?
Consideration is already there, sir.
The,
And almost
from
8
the
years have
equity
passed,
point,
this
from the
improved
equity
order
point
has
of view, also, Your Lordship is also,
This agony should end.
Yes, brother has rightly pointed out that now this agony of these casual laborers should come to an end.
they'll keep on supporting the
This
agony.
will come to an end whenever we decided. Otherwise, they're always hopeful that now this order will pass, now this order will pass, nothing. They're wasting their money and time.
Or, I do not know what are the documents they have produced, my lord. If Your Lordship gives an opportunity, let me check also, my lord, and let me also have a discussion with them. Maybe that's, my lord, if I may submit, my lord, maybe whatever has fallen from Your Lordship, my lord, let me have a interaction with my clients. They may not be, they may, my lord, may not be further interested to pursue. Let me say,
What these
Weeks
people
time.
will say,
week's time, my lord.
you'll say the
On that
court
day,
is
my
not
lord,
agreeing. They'll say, okay, sir, nahi agreeing, and then the whole instructions.
let me have a week.
Let's let agony be put to end.
That is what I will suggest them, my lord.
That's all.
That whatever has fallen from Your Lordship.
It will be only by deciding this. Then at least you will also be able to tell them the last word, okay, nothing will happen.
That I want to say before Your Lordship passes the order.
Okay, tomorrow?
Let me have a week, my lord. The people are from. Any day next week, my lord.
Mr. Chaudhary is the president of the Cooperative. Yeah.
I'm doing it pro bono, my lord, because I feel for them. Otherwise, legally speaking, Your Lordship is right.
Mr. Chaudhary pays for and granted time to complete it. Mr. Chaudhary has submitted that he may be granted some time to seek instructions from the petitioners. Time paid for is granted list on Tuesday.
Any day. Obviously.
13th.
And on that day, Mr. Chaudhary, I think so, you'll only.
I may not
about
take
the
Your Lordship, I may
instructions
not
and-
take Your Lordship's time, my lord, on that day. I hope so, my lord. Obliged.
Item 17.
May I please your lordship? Lordship, here I am aggrieved by the order of the learned single judge, lordship. The order is at page 116. Lordship, what happens here, the appellants herein are members of a armed militant force. They have surrendered long back in the year 2000. At that time, there was a scheme for providing employment to those surrendered militants, and similarly situated persons were given employment. Accordingly, we had also applied for the various posts under the government lordship. And when nothing has been done in the first round of litigation lordship, that is at page 81, we had approached this honorable court, and honorable court was pleased to issue a direction lordship.
Yes.
Lordship, the order is at page 81, Lordship, the first round of litigation, Lordship. There was a direction.
Do you have any answer to the para number 6 of the learned single judge
Lordship.
of the judgment, impugned judgment?
Lordship, these are the petition addresses. In this regard, I have to submit that, Lordship, there are
It is the
communication.
grievance of the petitioners that the petitioners are entitled for appointment, not any other rehabilitation under the scheme. However, learned counsel for the petitioners has not been able to show any scheme or policy decision of the government that surrendered militant shall be appointed on to government post. कौन सी post है बता जरा. Scheme or policy of the state government, you please show us.
Lordship, one, the revised scheme for surrender, that is annexed at page 74, Lordship. Though not,
74.
Lordship, though not directly, but there is a scheme, Lordship. It's 74.
Regarding the petitioner form.
74, it starts at 74 and the relevant part is at page 75, Lordship.
Revised scheme for surrendered cum rehabilitation of militia in the northeast. Yes, which
Lordship, the
clause you are-
benefits under the scheme, page 75, benefits under the scheme, Lordship.
benefits under the scheme.
Lordship. That is point number 2, an immediate grant of rupees 1.5 lakh to be kept in a bank in the name of the surrendered as fixed deposit for a period of 3 years. The money can be withdrawn by the surrendered after 3 years, subject to good behavior. And immediately thereafter, the paragraph, page 76, there is a note, Lordship. In the event of a surrendered being able to secure any government job, either in central government, PSU, army, state government, cooperatives, where the central state government has a share, this amount will not be given to the surrender.
In the event of surrendered, a surrendered being able to secure,
Any job. If they,
secure,
Lordship,
able to secure.
if they,
It's not that the state government will, or the government will, grant the, give them employment.
Lordship,
Secure by your qualification, if you secure, then you'll not get the money, otherwise you'll get the money.
Lordship. My case is that, Lordship, my case has been processed and only pending for cabinet approval. And also I have annexed one letter, Lordship, whereby it has been.
The state may give you the relief, or may not give you the relief, but ultimately we are bound by any policy of the state government. Taking into consideration that policy scheme, we have to issue a mandamus to the state government that provide them the job. Is there any compelling provision in that scheme?
No, Lordship, no.
Then
But in the
what was
earlier.
wrong with the order passed by the learned single judge?
Lordship, another letter that is of, that is a communication, Lordship. We got to consideration of our case, Lordship, that was not in record, Lordship. That was not considered by the single
Maybe
judge.
the state government has several considerations. Ultimately, how we can issue a writ of mandamus?
Lordship, the letter is at page 89, Lordship.
89.
89, Lordship.
Yes.
Page 89, Lordship, it is a letter by the Joint Secretary, Government of Assam, Home and Political Department to the Under Secretary, Government of Assam, PWD Roads.
Yes.
May I read the letter, Lordship? Subject, judgment and order of Honorable Guwahati High Court in WPC number 5456 of 2013 regarding rehabilitation of surrendered militants. Reference letter number so-and-so dated 8/11/2018.
In inviting a reference to the letter on the subject cited above, I am directed to forward herewith a petition received from so-and-so and others requesting the government for the employment in the grade 3 and grade 4 vacancies in the establishment of PWD building on the strength of the judgment and order passed by the Honorable Guwahati High Court in WPC number so-and-so. Government in the political department has recommended for consideration of their cases by way of condonation relaxation of their ages for the post applied under the PWD in the light of the order of the Honorable Court.
A relaxation in the age was only provided. There is no mandate that provide them appointment. Only if you have applied for that, relaxation means will be granted to.
Lordship. We had applied, Lordship, and
You applied and if the relaxation is not there, that is a separate cause of action. How can we ask them to give them employment?
my case is that earlier also there was a direction from this Honorable Court to consider the case, and thereafter it has been processed, Lordship. The process has taken place. In the meantime,
That's
they
the
have.
problem. The rate could have been decided only in the year 2000 itself, and there is no such provision. Again, that granted liberty and then again.
Lordship, my case has been processed. That is my ground, Lordship. It has been processed only pending for cabinet approval.
If you have
Lordship.
applied, any surrendered militant has applied for a government job, then only your case was processed only for the purpose of whether his relaxation is granted to him or not. That was the only, there is no mandate that employment will be provided to them.
But if Lordship, the records are called for, then everything will be.
There must be some mandate, records, for what we will call for the record.
Another thing, Lordship, on the last litigation, Lordship, the Honorable Court had issued a direction to consider their case, provided that the similarly situated persons are given employment, Lordship. On the same ground, I have annexed the appointment letter also. They were given employment in the year 2001 itself, Lordship. And we were
Vigilate the
discriminated, Lordship.
without there being any provision, if they have been
At that time,
provided
there was
appointment.
a.
Then giving such direction to the state government amounts to perpetuate the illegality. That can't be.
Lordship, the record may be called for and thereafter Lordship will pass order because my case has been processed, Lordship, only pending for
Certain what?
cabinet approval is awaited. My case has been processed and posted identified.
Better to pursue before the state government for the purpose of that. So cabinet may pass any proposal and grant appointment to them. We can't order any such direction.
Lordship, in fact, in their affidavit, Lordship, the file by respond number 1, they have stated that the applications were received by them and recommended for consideration of their cases. The responses themselves stated also in page 94.
Get that application pursued.
That is not the correct submission, Lord. In fact, the Home and Political Department, they have said that the relaxation of age, as Lordship has already observed, Lord, relaxation of age has been recommended and not for appointment. And in the affidavit, page 95, we have stated that the as on 1/1/2021, petitioner number 1 is 54 years of age. And the petitioner number 2 and 3, they are of 51 and 51. So by this time, they are 56 and 53 respectively.
Still they have 3 to 4 years left.
3 to 4 years. And in fact, there is no.
You provide them employment.
No,
they are
there is.
eager to serve the state.
So there is no such scheme, my lord. In fact, the largest single judge has considered their case, my lord, and my lord, the paragraph 10, a time limit has been given to the government that within 6 months, whatever proposal has been muted for rehabilitation of the present petitioner, already a scheme has been, the scheme is there, my lord. Under that,
the proposal that was
as a
stated,
matter of right, they cannot claim, my lord. It is up to
even if
the-
they get
it is under
employed,
the
they'll
scheme.
work for a few years and they'll retire only. When they will get the opportunity to serve, considering the.
It's a mockery. It would become a mockery. Only for 2-3 years, grant them job and then.
Lordship, the letter that regarding the proposal that is at page 115, they were given rehabilitation scheme under the existing Swavalamam scheme of rupees 1.5 lakhs each. Lord.
Yes.
Anything else?
No, no.
Okay. The Central Court of Appeal is filed on behalf of the petitioners. Being agreed with the order dated 6/12/2023 passed by the learned single judge whereby the petition filed by petitioners has been filed by the appellants container, appellants are in this. Stop. The defects of the case are that the appellants claiming themselves as surrendered militants has approached this court by way of filing writ petition number 5465 public 2013 with a prayer to direct the state to provide them employment as being surrendered militant. To stop. The aforesaid writ petition came to be disposed of by this court by the order dated 27/7/2018 with the direction to the respondents to consider the case of the petitioners and grant them suitable relief and rehabilitation, keeping in mind the fact that they have joined the mainstream with the hope to be resettled, and that similarly situated persons were given benefit of employment. Stop. The pursuant to the direction given by this court, the cases of the petitioners were considered. However, the government of Assam, by the order dated 4/1/2022, has turned down the request of the petitioners to provide them employment in the state government. Full stop. Being agreed with the same, the petitioners have preferred writ petition before this court, which came to be dismissed by the learned single judge by impugned order. Hence, this appeal. Full stop. Having heard the learned counsel for the parties and after going through the material available on record and particularly taking into consideration the observation made by the learned single judge in para 6 of the impugned order, which is reproduced which is reproduced herein, we don't find any merit in this appeal. Full stop. Even before us, the counsel for the appellant has failed to satisfy that any scheme or policy of the state government is in existence, wherein it is provided that the surrendered militants shall be provided appointment in the state government. Full stop. The learned single judge, while closing the writ petition, has already issued a direction for rehabilitation of the petitioners under the rehabilitation scheme. Therefore, no further direction is required to be issued. This intra-court appeal is dismissed.
Much obliged.
Item 18.
In this PI decision of the government,
Yeah,
which
for
is
the government.
put to change in the public just litigation manner, is inclusion of some of the communities as a protected class under the Assam Land and Revenue Regulation manner.
Inclusion of non-tribals in the tribal areas, man. This is
Now,
the.
provision is there. I mean, what has happened, my lord, in this case, my lord, we have filed our counter. Now, in course of hearing, my lord, records were directed to produce. Records have come, my lord. Then thereafter, my lord, since the records were bulky, I took the, my lord, permission to file an affidavit in a precise manner. Thereafter, this affidavit, I have not been able to file till date. When I
So do you have any objection?
No, my lord, only some time, short time has given one. Only very short point, my lord, only satisfaction.
because the cabinet subcommittee was.
When the DG so and so. Please for some time. To file further counter affidavit. With further counter affidavit with further details. Time period for is granted. This not. When?
Counter I have filed. Counter I have filed, my lord, only for this
Further
document.
counter.
My lord,
Yes,
4 weeks.
just after 4 weeks, we did this console.
Implemented.
They have granted time to intervener. You have been implemented as party. Okay.
Yes.
Intervener.
Fine.
Obliged.
Item 19.
May I please your lordship? My lord, this is an intra-court appeal, my lord, filed by the state against the, my lord, order passed by the learned single judge in the writ petition. My lord, facts in a nutshell is that, my lord, the writ petitioner was settled, my lord, allotted with a plot of land way back in the year 1992, my lord, measuring, my lord, 2 kotha 10 desa. Now, my lord, in the year 2006, on account of, my lord, holding the 33rd National Games, my lord, the authorities, my lord, dug a large portion of area, my lord, for holding the event of rowing. And, my lord, for that purpose, specific part and parcels of land were, my lord, acquired by the state government. And specific part and parcels of land were also requisitioned by the state government. Before the Honorable Single Judge, an affidavit was filed on behalf of the District Commissioner stating that neither the land of the petitioner was neither requisition nor acquisition for the purpose of holding national games way back in the year 2006. Be that as it may, my lord, and in that writ petition, my lord, the authorities of the national games were also arrayed as, my lord, party respondents. The writ petition, my lord, proceeded ex parte against the authorities of the national games at that point of time. They never appeared and they never contested. Their stand were unknown to the court. But nonetheless, my lord, since admittedly, my lord, the petitioner's plot of land was severely damaged, making it, my lord, unfit for human habitation. Therefore, the learned single judge, my lord, passed an order, my lord, directing the commissioner and secretary to the Government of Assam Revenue Department, as well as the district commissioner of Kamrup Metropolitan District, my lord, either to compensate the petitioner with reasonable compensation for the loss he has suffered, or to provide him with an alternative plot of land. Against that order, my lord, the state has preferred this appeal. During the proceedings of this appeal, my lord, a move was made, my lord, and from this honorable court, that why not, my lord, the petitioner be allotted with any other plot of land, since his plot of land was damaged. Authorities, my lord, swung into action. Authorities, my lord, made a spot verification, and they found, my lord, that out of, my lord, 2 kotha 10 acres, 1 kotha of land, my lord, was not, my lord, damaged. It is still fit for human habitation. And, my lord, so far as the remaining 1 kotha 10 acres of land is concerned, my lord, a separate plot of land was duly settled with the, allotted with the writ petitioner on consideration of a nominal, my lord, token premium of only 1 rupee. Now, my lord, after having done so, the petitioner, my lord, that is the private respondent 1 out here, my lord, he had come up with an interlocutory application stating that that alternative plot of land which has been, my lord, allotted to him is also not fit.
Now, that is a question of fact. Then, my lord, under that circumstances, this honorable court again directed the authorities to find out if there is any other further alternative plot of land. Now, lordship is well aware, my lord, in the city of Guwahati, my lord, there is a very dark and scarcity of, my lord, government land, disposable government land. So this is how, my lord, the matter stands here. So we are not entering into the merits of the case. Whether, if at all, my lord, the state government was negligent, my lord, in damaging the property. This is my basic case in the writ appeal. Of course, I will not be entering into the merits. So this is how, my lord, stands. And time and again, my lord, we have inquired with the authorities. We have placed, my lord, the instructions received from the authorities before this honorable court. It is on record, my lord, that no suitable other plot of land measuring equivalent, my lord, quantum of 1 kotha 10 nasa is found, my lord, to be allotted to the writ petitioner. Now, whether, my lord, this honorable court would at all direct the state authorities to compensate the petitioner in monetary terms, then, my lord, the question will arise, my lord, who is going to pay the money for whose damage, whose negligence, my lord. This is the least, my lord.
You have already allotted the plot to him?
Yes.
And with his consent or what?
Yes. There was a my lord meeting, my lord, of the SDLSA, my lord, subdivision and, my lord, land advisory committee. There is a committee constituted under the rules, my lord, to find out, my lord, proper areas. Then, my lord, that area was, my lord, earmarked. That alternative plot of land. Of course, my lord, his consent was not taken.
Petitioner, respondent's consent was not.
Yes, respondent number 1, that is the writ petitioner. Now he files an affidavit that he went. And later on, my lord, he was invited by the district authorities, please come and show us, my lord, where other plot of land. If there is any government plot of land which is visible to you or which is known to you, kindly intimate us that he is not cooperating, my lord.
No. That is, my lord, wrong submission, my lord. Petitioner times and again approached the deputy commissioner as well as circle officer, my lord. And question is this: how the petitioner identified a land which is land showing that this plot of land is vacant, but authority said that that plot of land is already settled with other purpose. How the person concerned identify land, my lord?
He read it finally.
Well,
Having heard the land council of the parties for quite some time, we are of the view that matter requires consideration, admit. However, note as the parties are already represented, there is no need to issue notice of in due course.
I'm so obliged.
My lord, a date may be fixed, my lord. My lord, a date may be fixed, my lord. It is since 2 years, my lord, it is taking time, my lord, for
The month of May.
List this matter for hearing in the month of May 2024.
And so obliged.
Obliged.
Right hand. सारे ऑफिसर क्या करेंगे दिन भर काम नहीं करेंगे प्रेजेंटेशन होता है
Yes.
Item 20.
My lord, in this case, Lordship may kindly have a look at the last order dated 19/9/2023. They have submitted before the court that one inquiry committee has been, one-man inquiry committee has been constituted. And the report is to submit before this court within 2 weeks.
Lordship, the inquiry committee has submitted a report, Lordship, on 4/1/2024, Lordship. Now, Lordship, but Lordship, some time is required, Lordship, for the government to examine it at the report, Lordship. Therefore, Lordship, I seek, Lordship, 4 weeks time, Lordship will bring it on record, Lordship, in the meantime, Lordship. Lordship, the government is examining the report.
But last time on 6th of October 2023, you
Lordship,
granted time to produce the same before this court.
Lordship, the inquiry committee sought extension of time, Lordship, to submit the same, and the same was submitted on 4/1/2024, Lordship.
My lord.
Lordship,
My lord,
4 weeks time, Lordship.
2022 case, my lord, that they are to expeditiously action.
And what's it with the respondent is submitted that
January.
January.
inquiry commission has submitted its report to the state government only on 4/1/2024. She has submitted that she wants some time to produce the same on record. List on so and so 4 weeks के बाद की date है.
Deep leverage.
Item 21.
Well, in this case, with all respect to the senior Malad, I am appearing for respondent number 3, Ministry of Home Affairs Malad. After the filing of affidavit by the respondent 1 and 2, Chief Secretary and Department Malad, a certain Malad instruction is sought from the Ministry of Home Affairs Malad. I am still not received instruction Malad. I have already communicated with the Ministry Malad. 3 weeks time Malad maybe given Malad.
Yeah, Mr. Parasar.
Malad.
So Parasar earlier also 6/11 to.
Yes, Malad. I have already. I have sent twice. I have sent mail, Malad. But
that is your between you and
yes,
central
yes.
government. What we can, how we are concerned with.
Malad.
Either you submit your response or otherwise we'll close the opportunity.
At least one chance, kindly, Malad.
Yes.
Because the evidence is required from the government of India.
Council for the respondent number 3 of the Union of India is granted last opportunity of 4 weeks to file affidavit on behalf of the respondent Union of India. List on so and so 4 weeks के बाद की date है.
11.
I'm sure.
Item 22.
With apologies, we required to file our affidavit in opposition. A final last chance was given to us. But there's a challenge.
Chance given to you.
It was given.
We have not filed.
My lord, we have not filed it. There's a certain reason why they've challenged a provision of a rule which, my lord, denies the LP school teachers to vie for the post of principal. In fact, my lord, we had set up committees to try and find out a way if their qualifications, those who have the qualifications for the principals, can be accommodated. This took some time, my lord, and we have not been able to file the affidavit. There has been no decision by the committee as of now. Perhaps, my lord, all I can do is to pray for some time to file the affidavit.
One more last opportunity.
Perhaps, my lord, if
Provided you pay cost. How much you propose or we propose?
It was actually in an attempt to see if the petitions can be,
Maybe
something to be
grant
called out.
another
That is what we tried.
on cost.
And my lord, but it was not that we have not taken the otherwise on the ground of law, my lord, we can get ahead with the matter because they've challenged the provision of the rule. We have to show certain things. Factually, we have nothing to deny on that, my lord.
If you don't want to file any counter, it's okay, we'll hear you.
My lord.
He has to satisfy us, and then only you have to
My
argue. Really you want to file counter,
lord.
then
My instructions are not that we will not file a counter, my lord.
your instructions are, you have to file a counter. But for that, you have to file. So, on 17/10/2023, last opportunity was granted to the respondent state to file a reply to the writ petition. While observing that no further time shall be granted, learned counsel appearing for the respondent state has submitted that the reply could not be filed, the counter to the writ petition could not be filed due to some unavoidable circumstances. And he pays last opportunity, one more last opportunity to file the reply. Well, granted you last opportunity, we are granting you last opportunity, otherwise the opportunity of filing reply will be closed on the next day. Be sure. कल क्या last opportunity भी? One more last opportunity to file counter to the writ petition. So, in the interest of justice, one more opportunity is granted to the counsel for the state to file counter to the writ petition. With this understanding that if the reply is not filed by the next date of hearing, the opportunity of the state to file reply counter to the writ petition will be closed.
That may be fixed, my lord. That may be fixed, my lord.
Yeah.
My lord.
Which date? Both of you convenient.
Oblige.
Yes.
Item 23.
Lordship, here I am appearing for respondent number 1, Lordship, and petitioner in person several occasions not appeared, Lordship.
Petitioner is not appearing.
Not appearing, Lordship.
Who is sponsor for the petitioner?
D.
So they don't say.
Sorry.
Petitioner present in person.
D. Saitya.
No one is present on behalf of the petitioner. it is noticed that on 30th of August 2023, 21st of September 2023, and 8/12/2023. Also, none was present on behalf of the petitioner. In such circumstances, this petition is dismissed in default for want of prosecution.
Item 25 and 26.
My lord, I am 26, my lord. But then so far, my lord, the affidavit has been filed by the respondent number 1 and 2, 3, 4 yet to file. I have responded and reply also.
You are the item number 26.
I am on 26, my lord.
And the reply is filed on behalf of?
My lord.
Who
Yes,
reply?
one they have filed, my lord.
Lordship, I have filed the affidavit on behalf of respondent number 1, who is the Revenue Department Registration Branch. And your lordship, regarding the stance of the other respondent, your lordship, it is quite similar.
But even when,
I
my
have
lord, the
received the, let me submit this. I have received the pair-wise comments, your lordship, from respondent number 3, the superintendent of stamps. So their stance as well as respondent number 1 stand is exactly similar, your
Your
lordship.
concept
So
of the
it is
respondent number 1 as well as 3 also?
Yes. So if that's why this affidavit separately for respondent number 3.
There is
was
no
not
requirement
filed.
of filing a separate
Yes.
affidavit.
Yes, stance is almost same, your lordship, exactly same. So on. so
What
on-
about the other respondents?
4, my lord, they have to file.
You have to file reply or?
I'm appearing appearance for the Stockholding Corporation of India. Per se, the challenges to the policy decision of the state government to implement the e-stamping process, your lordship. We are only the implementing agency. So regarding
They
that,
are also not in requirement. of
at this
filing
stage,
any-
perhaps it may not be required, your lordship.
They are not ready to file reply, what we can do?
Because if there is no prayer per se that, because once the decision has been taken by the state
You have
government,
to
we are only
implement it.
implementing it.
Yes.
My lord, there's certain allegation against the stockholding also there, my lord. The grounds is there. Because they are charging the more money, whatever is, my lord, for bond paper, they are charging 3 rupees per day now as per the new policy. But the bond paper cost is 50 paisa, my lord. So this is some allegation against them also, my lord. So that to be, my lord, be reviewed by the your lordship, my lord. Because the illegality and, my lord, irregularity and
If they are
impropriety.
not eager to file reply, how can?
Okay,
you
yes, sir,
force
they have
them?
to file a reply, my lord.
Huh?
They have to file a reply, my lord.
They have to file, and if they are not ready to file reply, what?
Then, my lord, it is lordship can fix for the hearing, my lord.
Nikhil, and counsel appearing for the respondent number 1 has submitted that the reply on behalf of the respondent number 1 is already filed. And has also submitted that she is also appearing for the respondent number 3. And the respondent number 3 are adopting the reply of the respondent number 1. Reply filed on behalf of the respondent number 1. Stop. Learned counsel respondent number 4 has submitted that 4 and 5. 4 and 5 has submitted that since no specific relief has been claimed against the respondent number 4, there is no need to file any reply to the current petition. Yes. Respondent number 6. Respondent. Respondent number 2 in item number 26 में 3. She is appearing for respondent number 3.
Both
He
3
is also appearing to entry, my lord.
superintendent of stamps. What has happened, your lordship, they have received the pair-wise comments from respondent number 3. They also had received a copy of the pair-wise comments. So I think he's okay, he's saying this.
Only on 2. Yes, what do you want? You also not required to file?
We have also received the draft for my, we also put in for by filing.
This is by 3. This is same as 1. I already submitted to honorable.
We'll adopt the.
Then counsel appearing for the respondent number 3 also submit that the respondent number 3 is adopting the reply filed on behalf of the respondent number 1. Also. In view of the above, let this petition be listed for hearing. When?
My lord,
In the month of May 2024. What about?
on April, my lord,
The tag
April, my lord.
matter, item number 25, the PIL. I don't think the service is complete, your lordship. The office note in the morning, I have perused.
The petitioner takes steps for service of notice.
I think respondent number 4 and 5 still awaited. Okay.
I'm entering appearance for the respondent numbers 4 and 5.
Respondent number 4 and 5. Yes. Likhiye, Mr. Alonso, put in appearance on behalf of the respondent number 4 and 5. Service is therefore complete. You need to file any reply or what?
I will file my reply in this case, your lordship.
Respondent, counsel appearing for the respondent number 1. Respondent state, please for time to file reply to the. And the same parties are there?
Same parties, your lordship.
Respondents are same.
Counsel appearing for the respondent number 1, 2 and 3, place for and granted time to file counter to the writ petition list in the list in month of May.
My lord, that may be prepon, my lord, April, my lord, lordship.
Month?
Prepon, my April, my lord.
Before?
April, in the month of April, my lord.
April, of April, third week of April.
Lordship, with regard to item number 25, I have additional prayer, Lordship. In our pleadings, at para 5, there are certain typographical error, Lordship. For that, we have filed additional affidavit as well as we have filed our interlocutory application also. Check that has not been taxed. Lordship, we have that may be placed.
Again, it will be listed.
Date 23rd. Obliged, your lordship.
Item 27.
Wait, please, your lordship. Your lordship, kindly see order dated 8/11/2023, my lord. 8/11/2023. So now, my lord, they place instruction.
Lordship, today morning I have received this instruction, your lordship.
That is in process, my lord. They are in the last stage, my lord.
FIO has been cleared, your lordship. Further 4 weeks' time is required for the disbursement of the money. The amount is also mentioned in that letter.
39 lakhs.
Yes,
13.
yes, your lordship.
My lord, let them.
Okay. Then concept of the state has produced the communication that is produced communication receipt, communication dated 7/2/2024 sent by the
Joint Secretary.
Joint Secretary to the
Revenue
Government of Assam, Revenue and Disaster Management Department, wherein it is whereby it is informed that the matter of clearing the bill amounting to rupees 39,46,179.00 to the petitioner is under process. Full stop. The said communication is taken on record. The copy of the said communication is taken on record. Then counsel for the respondent number one raise 4 more weeks to do the needful. Time paid for is granted. This up to 4 weeks.
Worship,
Yep, yep.
that communication was on behalf of respondent number 2. There are other
We
departments.
have already written his name, joint secretary and something, not community.
Worship has
We
mentioned.
have mentioned the designation joint secretary to government of revenue. and disaster management.
Mention.
Obliged to.
We have mentioned.
Yep, yep.
Item 28.
Ma'am, please, Lord. My lord, this case relates to the compassionate appointment, my lord. At the first stage, my lord, the honorable single judge rejected, my lord, did not issue notice. Now, this morning, my lord, we came to know that our case was referred to the DLC, my lord. So we have to challenge that DLC, my lord.
So you want to withdraw?
Appeal, my lord, does not survive.
Appellant has submitted that in view of the subsequent development, this appeal has become infructuous.
My lord.
Dismissed as infructuous.
And we may be permitted to hesitate, my lord, appropriate forum.
That we are not making their simply
Lost.
observing that this petition is become infructuous, dismissed as infructuous. That's all.
Diploma.
Item 29.
So here I have received the instructions today in the morning, Lord. They have informed that the other person, Sambaru Roy, he had, there was order that the claim of the appellant is that one similarly situated person, he has been given the benefit. And he is also claiming that benefit. My instruction says that the other person has got the benefit. But here at the same breath, they said that he's not entitled for regulation of his service. And he is entitled for the minimum pay benefit only. But some discrepancy I find in my instruction, my lord, that I may be given 1 week time, my lord. I have to get the clarification, my lord.
Yes, I've got no objection. The fact is that, my lord, Government of Assam has regularized all the persons who had been serving since 1994. And, my lord, it is the admission of the executive engineer, being a respondent here, that by mistake 2 names were left.
Yes, sir.
Now he's
Yes,
seeking week
yes,
strength.
yes.
At the request of land council, so list this matter on so and so. After a week, he did the night.
People of like.
Fine.
Item 30.
May I please, your lordship? Pursuant to issuance of notice, today the matter is listed, lordship. We are allowed to file our response letter. The matter pertaining to, they have challenged the blacklisting order of 2019 for a period of 2 years, lordship. 2 years has already been over, lordship, in the year 2021. That fact was, we have placed before the learned single judge and learned single judge. Without, apart from that fact, the learned single judge passed the order in merit, lordship, and thereby dismiss the writ petition. Lordship, we can, lordship, may allow us 3 weeks time for filing our affidavit, lord. Yes, lordship.
For this stigma part, I don't know. Whether
Yes.
Why you want to file affidavit in a?
No, but lordship may fix up for a hearing, lordship, any date, lord. Because in writ petition we have filed affidavit, but only because of learned division bench.
Acha, Mr. Abbas, one thing, the period of 2 years.
Yes, no.
That is now over.
Yes, yes.
So from that point of view, by flux of time, your cause has
Yes, my.
expired. Why do you want to pursue this matter now?
But lordship, stigma is there, lordship, and lordship. Their consequence penalty has also imposed.
You
by-
filed affidavit before the learned single judge.
Yes, lordship. We have-
That's enough.
Only because of, division bench issuance of notice, lordship, the respondents are allowed to file counter affidavit, therefore that's part.
And concept of the respondent has submitted that since Counter the petition is, has already been filed. There is no requirement of filing counter. There is let appeal. He plays some time to argue the matter, less counsel and so on. Date आप जो बता दे अपनी choice की.
Can it be on 5th March, Lordship? No, what's it, thereafter?
Whatever the date.
Agree on a date.
Abolishment.
Item 31, Cooperative.
Lordship, in this item 30, sorry, Lordship, there is interim Lordship that may continue, Lordship.
Interim order if I need to continue. till
Item
next
30,
day.
Lordship.
That's item number 30.
Sorry, my Lord. Abolishment.
Yes.
Lordship, I appear for respondents.
Yeah.
Already appeared with the order. Last of the land advocate for the petitioner took time for filing appeal reply.
Mr. Bora.
Lordship.
Where is Mr. Bora?
No, he is Bora. He is Bora. Sorry. He is the central government.
Mr. Mahanta. Where is Mr. Mahanta?
Today he is not seen, Lordship.
Not seen.
Not seen.
He is not present. Normally I work at
Adjourn for 2 weeks. None present. For the petitioner, adjourn for 2 weeks. Apparent. Adjourn for 2 weeks.
Oh, obliged, Lordship.
Item 33,
petition. This is petition.
May please, your lordship. May please, your lordship. Lordship, in this case, lordship, if Peru's lordship ordered dated 10/5/2023, there is a repetition is pending, your lordship.
10/5/2023.
Yes, lordship.
Yeah.
Lordship, there,
Controversy appeal resolves, consequent cancellation, this court applies the order of cancellation, they are telling it. That could be a positive outcome of that.
that matter is, the repetition is fixed tomorrow, your lordship.
Tomorrow.
For,
Yes,
for,
sir.
for
Yes, sir.
admission.
The repetition is fixed tomorrow. Let it be after.
After tomorrow, let it be
At the
passed on.
request of the land council for the parties, list this matter on third. Date up, whatever the date convenient to you, please.
Lordship, will do it. Much obliged.
item 35,
Me please, your lordship. Leading senior counsel in this matter has been elevated, your lordship. Therefore, we'll be engaging someone else, your lordship. If your lordship may adjourn the matter for 3 weeks on that ground. Lordship and interim may continue, your lordship.
Mr. When the concept, the simple content, the land concept of the petitioner seeks time to complete her instructions, less launch on story.
Lordship, interim may continue, lordship.
Interim order if I need to continue till next.
Item 35,
Obliged.
Lordship, a date may be fixed.
1st of March.
Obliged.
supplementary list, item 37 for orders.
May I please, your lordship?
Yes.
Lordship, this interlocutory application has been filed for condonation of delay, lordship. 1,469 days, lordship.
How much delay is there?
Lordship, 1,469 days, lordship.
Very few.
Lordship, issue is.
Very few days.
Lordship, issue is that lordship, he is suffering, still suffering from bone tuberculosis, lordship, from 2015, lordship. And he was outstation, lordship, for treatment, lordship. The respondent has filed affidavit, lordship. Lordship, may kindly see the affidavit, lordship.
Yes.
Lordship, paragraph number 2, lordship.
Paragraph number 2.
Lordship.
Counter affidavit or?
Lordship, I have filed, lordship.
What has happened to the criminal proceeding?
Lordship, he has already got acquitted in the rape case, lordship. And so far, lordship, child labor prohibition, he has convicted, lordship, and Since it is a minor offense, Lordship may
Here is a benefit of doubt, Lordship.
अब criminal proceeding में ये लोग कह रहे हैं पहले अगर बीच में इनसे फाइनल
Benefit of doubt, he got the.
No, Lord.
Sir, but it was a notice. Around taking his service. This was very clear. No, what I am saying is in the connected proceeding, में, connected
Filing it with application not going to be any technical.
ये रोल ब्लॉक होता है फिर जाएगा सुप्रीम कोर्ट पे उस
If it is suffering from some malignancy, then.
But he has not annexed document, all documents.
Documents.
Some of annexed, Lordship, but prolonged illness,
Ultimately,
Lordship.
from those, some of the documents we can gather is suffering from malignancy. Then the good ground.
I leave it to Lordship.
Okay. The matter comes upon for consideration of application under section 5, the limitation act with the prayer for condoning the delay in filing the present. In filing the appeal, in filing the present, in filing the appeal, full stop. In the application for condonation of delay, it is mentioned that as the appellant, as the applicant is suffering from malignancy, he is required to undergo treatment on regular basis. And on account of that, the delay has been caused in filing the present appeal. Full stop. Reply to the petition is filed on behalf of, the reply to the application under section 5, the limitation act is filed on behalf of the respondents, wherein wherein it is stated that the appellant has failed, the applicant has failed to satisfactorily explain the delay, hence no case for condoning the delay is made out. The application for condonation of delay may kindly be dismissed. Having heard the learned counsel of the parties and after going through the contents of the application under section 5, the limitation act, and taking into consideration the fact and taking into consideration the documents pertaining to the treatment of the applicant, we deem it appropriate to condone the delay, we condone the delay of 1462 days in filing the appeal. Hence, the application under section 5, the limitation act is allowed. The delay in filing the present appeal is condoned. Learned. Then you want to file counter or something, nothing? No.
In I appeal if necessary.
Office to register the appeal at its regular number and listed before this court of 2 weeks.
deeply obliged, Lordship.
If they are ready to argue or you are ready, this item number 38 and 39?
No, Lordship, I beg.
39.
38, Malad. Yes. Ready for arguments? at two.
Apology, Lordship, subject to correction, Lordship, it's a review petition, Lordship, was dictated as appeal, Lordship.
1-4, this, the delay in review petition,
Lordship, review petition, Lordship.
review before the division bench.
Lordship.
Okay, fine, review.
Supplementary list, item 38.
What was the date of the last two AGMs?
My lord, there was no AGM at all, my lord, because there was a COVID and my lord, the coordinate bench in the same cooperative society has allowed others to participate, saying that the relaxation is given. That was before the London single judge. The order is at page 19. It starts at page 23. And the relevant portion is at page 25. Para 8. Page 25 of that. And at page 27, the executive officer himself has stated.
Just Can you please give us the dates of the AGMs
My lord,
which were actually took place?
my lord, in previous 5 years, what was the contention in the notification? There was no AGM held. There was no AGM held. Because of the COVID situation, no AGM, and the cooperation department did not allow us to hold AGM because of the pandemic
Is
situation.
there any written order or?
My lord, because of that, in the Cooperative Societies Act only, my lord, 130A provides that the state government has exempted during COVID provisions. Section 130A.
138.
A. How about it?
Mr. Rajchandra, that is regarding disqualification of directors.
My lord,
That is not pertinent to 40 subsection 2.
my lord, here 40 subsection 2, what they have stated that because you have not attended the AGM,
Amended. Amended.
amended.
Nine? Mr. Talukdar, in last 5 years where AGMs held,
But in fact, that is what I'm trying to say. The pleadings is absolutely bereft of any details, my lord. Pleadings does not say that during the last 5 years, there was no AGM. In the synopsis, my lord, I find that they have admitted there were 2 AGMs, my lord, during the last 5 years. So therefore, it is contrary. The submission, my lord, oral submission is contrary to the synopsis, my lord. But in the pleadings, my lord, it is bereft of any details, my lord. When the 5 years started, which were, my lord, the years, the period where AGM was not held, these are absolutely missing, my lord, from the pleadings.
You just tell me, how many board of directors are there?
My lord, in fact, what I'm trying to say, they are shareholders, my lord. They are not the board of directors. In respect of the board of directors, this honorable court on the earlier proceedings, my lord, they have been allowed to participate in the election.
So they are the shareholders.
Shareholders, my lord. And the requirement is to be present, my lord, at least 2 meetings, 2 AGMs, my lord, during the 5 years. Now your lordship will see, essentially, the notice is put to challenge, my lord. The notice by the secretary. Now this notice, my lord, by this notice, no condition has been introduced, my lord. This is the requirement of the statute.
It's only that 42.
Exactly, my lord. This is the requirement of the statute. And this prescription, my lord, is staring on the face of the, my lord, petitioners, appellants, my lord.
My lord, your
They
lordship
sat
may
over the
look into
matter.
page 27.
Let him complete it, please. Yes.
My lord, they sat over the matter, and at the 11th hour, they have approached this honorable court, asking for, my lord, a permission to be, for granting, my lord, them to participate in the election, my lord. It is scheduled to be held on tomorrow. They are trying to, my lord, tinker with, my lord, the election process.
My lord, your lordship may look into their document where they have specifically admitted there was no election held. Page 27. The executive officer who has issued the notification has himself said, page 27, your lordship may look into. 20, 21 and 22 were not held due to COVID-19 pandemic and court cases. It is their document.
Page
27. Executive officer who has issued the notification.
27 page is different.
27, my lord. Order dated 4th July 2023. 4th July 2023. And he himself has issued the notification. Notification has been issued by executive officer. And board of directors appeared before this court when it was dissolved. So they don't remain as a board of directors. They also become a shareholder. And it was a one-man committee who has run the election. And by this notification, only those 14% will be allowed. Nobody will be allowed. Only those 14 who appeared, they will contest the election.
Appeared in the board of directors?
No, my lord, that those who have filed the earlier writ petition. Now the eligible list has been given, only those 14% are allowed. Nobody will be allowed to
Which
participate.
14% from 19/6/2023, that order.
That order, they are appearing in they are the only eligible candidate. Your Lordship, I have annexed the eligible list.
What is that?
Okay. 32. 32 কোথায় আছে? Usually উল্টা পাল্টা চলে আসে। কোথায় 32 আছে?
These are the petitions before that.
My lord, maximum of them. It is there, 32.
No, for youth carer, it's not mandatory. They have diluted it. You know, carer is not. 2 years attendance will not be nice. Okay, just statutory requirement guidance. If they have not attended, then again cannot be held. It is for the government to fill up. If it is taken up, we can ask him that. Mr. Talukdar, this 14 persons list is in the page 32.
Madam.
Have these people attended the last two AGM?
My lord, in fact, they are required to attend because as per these documents, it appears, my lord, 3 AGMs were not held. So the period is for 5 years. So at least 2 AGMs were held. So they were board of directors. So they are required to, my lord, attend the AGMs, my lord.
You just, whether these annexure 4 page 32.
My lord.
These 14% final list valid candidates for contesting AGM so and so.
My lord.
Whether all these 14 persons have attended 2 meetings in the previous 5 years, 2 AGM meetings in the previous 5 years or not.
Exactly, my lord. That is what I'm trying to pursue your lordships.
Yes.
They, my lord, are the board of directors. Without their presence, my lord, AGM cannot be held.
They attended
So
or
that
not.
instructions, my lord, I don't have, but they are allowed to participate, my lord, in terms of the, my lord, honorable court's direction, my lord. Because the honorable court in the earlier occasion found that due to the COVID, my lord, the election could not be held in time. So the disqualification which is otherwise attached, my lord, under the act, that will not ensure upon them.
That's another thing.
My lord. That is, my lord, relating to board of directors.
That's
40, my lord, what I'm trying to say.
So if the board of directors have not been able to attend the AGMs on account of that, no AGM took place, then how the shareholders can be forced to have this qualification?
My lord, in fact, your lordship will see there are 2 requirements.
Yeah.
One requirement is the board of directors is required to hold the election before expiry of, my lord, 5 years.
Fine.
And that is what the honorable single judge has held at para 8. If your lordship comes to para 8, the election, my lord, could not be held within time. If I take para 8, my lord, page 25.
Earlier repetition.
Page 25, my lord, whereby the board of directors were allowed, my lord, to participate in the election. Para 8, my lord, it starts, my lord, from 4th line from the top. Under such circumstances, the court is inclined to hold that due to non-holding of the election within the time provided, the S12 members of the board of directors, including the petitioners, would not suffer disqualification as provided under 44A and 41(4). So this, my lord, this incurs this
fact remains with the petitioners also, the appellants also.
Yes, my lord.
Since no elections were held and no AGM took place, how can you compel them? You should have this requirement.
No, my lord. In respect of the appellants, my lord, section 40 subsection 2 applies.
Fine.
Yes.
But here also the condition is, and what about this annexure 4? Annexure 2?
Annexure 2, my lord, I say that the
27.
executive officer, my lord, this order could not have been passed by, he is incompetent, my lord. A statutory provision cannot be relaxed, my lord, by him, my lord. This, my lord, is a nullity in law. This is, my lord, this is not valid, my lord. He cannot do that. It's a statutory provision, my lord, express provision of law. My lord, what I'm trying to say, my lord, like the other petitioners, the board of directors, they were required to approach this honorable court in time. They have come at the 11th hour. They know that section 40 subsection 2 is operating against them, my lord. Now at the 11th hour, my lord, they have come.
When the notice was issued?
24/124.
But this is a statutory prescription, my lord, under 40 subsection 2.
And we approach within that period. 24/124. And this order was passed, my lord.
Even then, this election again cannot help because schedule last date of submission of nomination is over. So I think if they succeed, there has to be a fresh schedule of fresh date of nomination or whatever.
The date for, last date for filing nomination?
My lord, everything is over. Tomorrow is the date of election in AGM. 8.
I let them go ahead, but there no approval will be granted in the next day. In the meantime, let them satisfy the state so that they can fine, otherwise the fresh regime must be held.
Well, can I, well, in fact, the writ petition is pending. This is a appeal against the rejection of the interim prayer, my lord. And secondly, my lord, there is an alternative remedy under the rules, my lord, 2019 rules, my lord.
What?
My lord, in fact, this is akin, my lord, to improper rejection of the nomination.
My lord, there only says 27 says, when an election is held, you can, within 3 days, you can, but if I am outside, how could I
That is
can?
in relation to election dispute.
The election dispute.
My lord, improper rejection of nomination, my lord.
Is not an election
will
dispute.
Come within that, my lord, purview.
No.
Then came up.
No. Only, my lord, the cooperation department cannot talk about the cooperative society. Like confirmation. Declaration of result.
Yes. Well, the notices and you go ahead with the election, the result may not be declared till the next day.
Yes, my lord. Then the one man has to run, my lord, the society, because the statutory prescription is that beyond 90 days, my lord, he
Who
cannot.
is running the society?
The one man committee.
One man committee.
One man committee is
Again, he'll run for 3-4 more days.
my lord.
We are simply fixing in the next week.
My
We
lord.
filed your response.
My lord.
We'll consider it.
My lord. Correct.
Yes, notice. Then, Mr. So-and-so is appearing on behalf of the respondent. The respondent state hai.
My
All the
lord,
respondents.
except 7, my lord, I am accepting notice on behalf of all the respondents, 1 to 6, my lord.
On behalf of the respondent number 1 to 6, let notice be issued to the respondent number 7. इसको जरूरत होगी क्या respondent number 7 की? Is there any requirement of issuing notices to respond?
No, my lord, no. I think no.
Respondent number 6.
But he has issued the, my lord, notification,
He
election
raised some
notification.
time to file reply. He placed some time to complete his instructions. Would stop. Having heard the learned counsel for the appellant on stay application, we deem it appropriate to direct the respondents number 1 to 6 to proceed with the election of the board of directors.
My lord,
Board of
election
Directors.
AGM, my lord.
Election.
AGM oblique election
My lord.
of the AGM
Cooperative.
Cooperative Society. कौन सा है?
Modhu Mosalmari Samavai Samiti.
Madhu Musulmani Samiti. However, the result of the meeting oblique election shall not be declared till next date of hearing.
Right.
List on Wednesday की date है, for next week.
My lord, can I have 7 days time, man, to file the affidavit?
The next business is holiday. Holiday. 16. 15.
16th.
My lord.
Item 39.
Yes.
My lord, I'm preferring this present writ petition on being aggrieved by the non-consideration of my applications, repeated applications that I have made, as well as, my lord, the notice that has been issued under section 13 of the Surface Act, as well as the, my lord, the symbolic position that they have taken. My lord, the facts of this present case is that on 21/2/2020, my lord, the sanction letter was issued to me for a term loan amounting to 7 lakhs of rupees and a cash credit of 11 lakhs of rupees. In that particular,
Yes.
in that particular sanction letter, my lord, there was a 12 months moratorium period, during which period I was supposed to construct that particular, my lord, the pig house, my lord, and where I am doing the farming, my lord. But with the advent of the COVID and the lockdown from 25/3/2020 to 15/5/2021, the said construction could not be complete.
Yes.
Hello. The construction could not be complete.
Okay, yes, you just please satisfy us regarding the maintainability of the.
My lord, may I please take, my lord, to section 17 of the Surface Act, my lord.
Yes.
Seventeen three, if I may take, my lord, to section 17, subsection 3. This section deals with application against measures for recovery of the secured debts. If the debt recovery tribunal, after examination of the facts and circumstances of the case and evidence produced by the parties, come to the conclusion that any of the measures referred to in the subsection 4 of section 13 take by the secured creditor or not in accordance with the provision of this act and the rules made thereunder, and requires resortation of the management of the resortation of property of the secured asset to borrow or other aggrieved person, it may by order. My lord, this particular section deals with section 13(4), my lord, and 13(4) specifically deals with when only if there is anything aggrieved by the issuance of the notice. My lord, but in my present case, there is an arbitrariness which has been done by the respondent authority, my lord.
It's despite that, it is for the DRT to consider. We are not supposed to, under Article 226, we are not supposed to consider.
My lord, certainly the DRT would consider, my lord.
Yes.
If, my lord, I'm ready to go to DRT. If that leave is granted to me, that I can place this particular facts of non-consideration of my representation before the.
Whatever available grounds, legal grounds, which you can raise, and if you can't raise those grounds legally, then we can't give you the liberty and we can't create any jurisdiction or whatever you mean to say, that another remedy to you. If it is the law doesn't permit, how can we do that?
My lord, my only constraint is as regard to 13(4), my lord, because 13(4) specifically says that if there is anything as regard to issuance of the particular notice, my lord.
Yes.
Not, the section does not allow the DRT to go beyond that particular scope of beyond that, my lord.
Yes.
So my basically, which I'm aggrieved by, is non-consideration of my applications, my lord, prior to immediately after issuance of construction, because they have not considered my application as regard to, they have not even visited my lord, my place, nor they have released the term loan, my lord.
Those grounds before the.
If I'm given the liberty, certainly, my lord, I will go, my lord.
It is always.
All legally
My lord, my lord, my lord.
Okay. After attempting to argue the matter for quite some time, and answer to the petitioner has submitted on instructions that he wants to withdraw this petition with liberty to raise all the permissible legal grounds before the before the DRT. In the proceedings under section 17 of the Securitization Act. Dismiss with liberty as prayed for.
My lord, if I may pray, my lord, I may be framed, I may be given a particular time frame. Till then, my lord, I will file the application within that time frame.
That's the whole,
My lord-
that's why only you easily agree, okay, sir, pass this order.
No, sir.
And then I'll ask for a stay order. No.
No, my lord, it is not like that, my lord. If 1 week may be given, my lord, so
please,
that
sorry.
they do not take any
Please,
coercive
sorry,
action
sir,
in that.
sorry, sir, sorry, sir. Before approaching this court, you should have approached the DRT itself.